Take a motion, please.
Thank you, Mr. Chairman. I'll make a motion to grant the application.
Second, all in favor?
Aye.
Application is granted. Thank you.
Application number 521-26, Augusto and Catherine Gomez, permission to leave in-ground pool having rear yard of 11 feet instead of required 14 feet, and pool equipment having rear yard of 2 feet instead of required 6 feet. Residence A District, west side of Simmons Drive, 394 feet south of Manistee Lane, East Islip.
Good evening, sir. Your name and address for the record?
Augusto Gomez, I live at 114 Simmons Drive in East Islip.
All right, and you're here on the pool side yard and the pool equipment side yard, rear yard?
Yes, sir.
Okay, any questions from the board?
No question.
No.
Planning, any comments?
No comment.
Is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Thank you, Mr. Chairman. In keeping with the zoning board procedures we follow since one side complies, make a motion to grant the application.
Take it a second.
Second.
All in favor? Aye. Application is granted.
Thank you.
Application number 522-26, Marjorie and Marie Bazile, permission to erect two-story addition, I understand that's a second-story addition, 16.5 by 41.5, leaving floor area ratio of 30.9% instead of permitted 25%. Residence B District, northeast corner of Cullen Avenue and Garrettson Avenue, Islip.
Good evening, sir. Your name and address?
Hi, I'm Teddy McLean, 43 Oriole Way, Dix Hills, New York.
Okay, and you're representing the Bazile family?
Yes.
Okay.
We're trying to request a variance for FAR of 30.9 instead of 25% on a second-story addition.
As far as the FAR of 30.9, you have any precedent for that?
No.
Planning, do we have anything in the area?
Nothing that would get them above 30.
Okay. Can you sharpen your pencil, bring it down to 30?
Down to 30?
Yeah.
Definitely.
Okay, is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Thank you, Mr. Chairman. Make a motion to deny the application, however, grant 30% FAR.
Take a second, please.
Second.
All in favor?
Aye.
Aye. Application is granted at 30%.
Thank you.
You're welcome.
Application number 523-26, Michael and Joanna Carmecci, permission to install in-ground pool, leaving second front yard of 15.3 feet instead of required 27 feet, to leave 6-foot fence on property line not having required setback of 10 feet, and driveway on rear property line not having required setback of 4 feet. Residence A District, northwest corner of Country Village Lane and Argyle Drive, East Islip.
Your name and address for the record, please.
Yeah, it's Michael and Joanna Carmisi, 68 Country Village Lane, East Islip.
All right. Planning, any comments on this application?
With regards to the fence, it actually doesn't need a variance at all. It meets the exception, which I double-checked with zoning. As far as the pool is concerned, it's numerically significant, but second front yards are tough, and it'll be entirely obscured by the fence, so I don't think it's a big deal.
Okay. Any questions from the board?
No questions.
Is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Thank you, Mr. Chairman. I'll make a motion to grant the application.
Can I get a second? All in favor?
Aye.
Aye. Application is granted.
Application number 524-26, Isabel Daniels, permission to establish accessory apartment pursuant to Islip Town Code, Section 68-602, resulting in floor area ratio of 26.5% instead of permitted 25%, and to leave driveway and shed having side yards of 1.6 feet and 3.9 feet instead of required 4 feet each. Residence A District, south side of Laurie Road, 459.21 feet west of Michael Lane, Brentwood.
Tom Trufaro, DTT Designs, 1165 Broadway Avenue, Holbrook, New York.
Okay, we're here on the accessory apartment and then the side yards, right?
Yes, sir.
All right. Any questions from the board at this time?
No questions.
Planning, any comments?
No comment.
Is there anyone else that'd like to be heard in this matter? All right, I'll take a motion, please.
Motion to grant that portion of the application for floor area ratio variance and the side yard variances, and to grant the accessory apartment for a period of 3 years. Second.
Thank you. All in favor?
Aye.
Thank you.
Application is granted.
Application number 525-26, Andrew and Rebecca Wright, permission to leave driveway having front yard occupancy of 50.6% instead of permitted 40%. Residence AA District, west side of Vanderbilt Boulevard, 300 feet north of Lockwood Avenue, Oakdale.
Good evening. Richard Bronchick, Bronchick, for JL Drafting, 707 Route 110, Farmingdale, New York.
Okay, and here just on the front yard occupancy?
Yes, sir, for the driveway, which was there when my clients purchased it 2 years ago.
Planning, any comments on this?
50 is about where the board would normally go for a busier road. I don't know, it would be up to you what you qualify as a busier road, I suppose. It's a 2-lane road, Vanderbilt Boulevard, but I can't speak to exactly how busy it is.
I think Vanderbilt tends to be a pretty busy boulevard, correct? Anybody?
I'm not familiar with it. We reserve 50% when it's Veterans Highway or something like that, but how busy is a 2-lane road?
There,
Scroll up.
well, it's a double, I'm sorry? It's a double yellow line, and there's really not much room to park on there. I have photos if the board would like it.
Our chairman says it's busy, therefore it's busy.
We
Yes,
bring it
sir.
down to 50%?
Yes, sir.
Okay. Is there anyone else that'd like to be heard in this matter? All right, I'll take a motion, please. Can I get a second? All in favor?
Aye.
Aye. Aye. Granted at 50%.
Thank you very much.
Application number 526-26, This LLC, permission to erect two-story dwelling on lot having width of 60 feet instead of required 75 feet throughout, and wetland yield of 0.55 instead of required 1. Residence B District, east side of Harrison Avenue, 1,005.81 feet south of 2nd Avenue, Bay Shore.
Good evening, Chairman, members of the board, Ms. Passaro. My name is Janice Whalen. My office is at 23 Green Street, Suite 205, Huntington, New York.
Just speak into the
Yes,
microphone.
I represent This LLC in our application to rebuild a house that formerly existed on the site since 1915. I'd like to hand up a couple of exhibits. I'll be very brief because I know the
Before
board
you-
has a lot of other
Ms.
matters.
Whalen, before you do that, a couple questions. First, are you rebuilding exactly what was there?
We're actually rebuilding it smaller, and where the old house was 2 feet over the property line, we're now creating a 14-foot side
So
yard
you're more in
setback.
compliance?
We're all zoning compliant except for the existing lot area and the yield, which was enacted after my client
And what
purchased the
happened
property.
to the home that was there?
It was burnt by arson.
Was it your client's arson?
No.
Because we take a very... we
Fair
take a very-
question, but no.
We
And
take a very dim view of ours.
just
You
for
know,
the record,
arson's one of those things that we don't like.
Okay.
I would imagine. My client is here, the managing member of the LLC, Mr. Spencer Shaughnessy. The Shaughnessy family has owned this property for 2 generations. They bought it in 1987, 2 years prior to the enactment of the wetlands legislation. I understand that might have, you might have questions, and I have Mr. Chick Voorhees, who's our environmental expert. I also have Mr. Mel Gonzalez, who made this beautiful rendering, if I could hand this up, and Mark Anderson, who is a real estate expert that could testify that this property is going to have no value if we're not, hopefully this board looks favorably upon our variance request. I'm handing up the CO as Exhibit A, and that shows the property was built in 1915. B is the survey of the existing house, or the former house before it was burnt down, which shows even though it was over the property line, it got a certificate of compliance. Exhibit C is precedent from this board for shortened lot widths on Harrison Avenue. And Exhibit D are 9 cases I found where this board varied the wetlands yield variance, not in Bay Shore, but in Oakdale and nearby properties. Again, we're making this application far better. And I also want, as a...
Just a second, please. Nick, what do we normally do with a 55% wetlands yield? You're the expert.
Okay, so it's not a good number, to be clear, but usually when we allow it and some of the things that she's showing are around that area, it's because it's sort of a demo and rebuild of an already developed property.
Mr. Wexler, just so you know, the wetlands impact every property on Harrison Avenue, but most of those properties were developed before the wetlands legislation. So we're going to be our dwelling is 100 feet from the flagged wetlands. So we're actually making this case a little better than the house that existed there.
So you're helping the town.
We're trying, we're trying.
Just a question, Ms. Whalen.
Yes.
Do you require DEC approval for this?
Actually, I'm going to have Mr. Voorhees speak to that. I'd ask that the board recognize Mr. Voorhees as an expert in the environmental field. He's got over 48 years of experience, and we're very grateful to have him on this application. Mr. Voorhees, I just have a couple of questions for you, for the board. Can you please summarize the expected DEC involvement for our proposal to rebuild a single-family house?
Back up. If you could give us his name and address, and then if you're gonna cite him as an expert, if you could give us his credentials besides
Absolutely.
doing it for 48
Mr.
years.
Chick Voorhees, he's a principal.
Well, he can do that himself, correct?
Sure. Good evening, thank you very much. My name is Chick Voorhees of the firm Nelson Pope Voorhees. Offices at 70 Maxis Road in Melville. I'm a certified environmental professional. I'm a member of the American Institute of Certified Planners, as are many in the audience here and on the stage. And I have done literally hundreds of DEC freshwater wetlands applications, so I feel qualified to speak to that matter.
Thank you, sir.
What do you want to say?
Yeah, no, what would you like to say as far as, yeah?
Mr. Voorhees.
Thank you. So I've looked at this. I know that the DEC would look very favorably at the 100-foot building setback. The 100-foot from wetlands is a jurisdiction line, so that any disturbance within the 100 feet would require a DEC permit under Article 24 of the Environmental Conservation Law. Any minor disturbance would easily get a permit from DEC. I am 100% certain that this would be approved by that agency.
If they don't get a DEC permit, they can't build it?
That would be true,
Okay.
but
Alright.
there is a portion of the property that's not even within DEC jurisdiction. So any permit that we would need would just be for a little bit of minor disturbance to construct the house, because the house will be 100 feet from wetlands.
Thank you.
Okay, thank you.
Thank you, Mr. Voorhees. Just another little bit of history. This property held rental permits since 1988. The Shaughnessy family had it participate in the Section 8 housing project for the Islip Housing Authority. So we're very eager to rebuild and hope the board looks favorably upon our application.
Okay. Planning, anything else?
No, I have nothing further.
Okay. Is there anyone else that'd like to be heard in this matter? All right, then,
Somebody has their hand up. You can't see them.
I'm sorry.
I'm ready.
No,
No,
you can't
If
see
you'd like to,
because of
please, please come up to the
the
podium.
screens that have been put in our
I
rooms.
apologize, I did not see you through the screen.
Hi, good evening. I just wanted to find out
Can you give us
specific.
your name and address, please?
Sure. My name is Jareen Skinner. Reside at 36 Harrison Avenue. I just want to find out specifically what this property will be used for. Is it going to be a group home? Will it be a rental? Or will the individuals that are building the home, will they be residing in the home?
I can answer that question.
Thank you.
This will not be.
Ms. Whalen, if you could stand to the,
Address the board, please.
yes.
This will not be a group home. We don't know yet whether it's going to be a rental or whether or not Mr. Shaughnessy is going to reside there, but it's a single-family residence that we're proposing, as existed on this property for very many years.
Okay. Does that answer your question, ma'am?
Not really. It's still indefinite, but thank you.
It's not going to be a group home, I can promise you that.
All right. Is there anyone else that'd like to be heard in this matter? All right, now I'll take a motion, please.
Motion to grant the application.
Second, please. All in favor? Aye. Application's granted.
Thank you.
Thank you.
Application number 527-26, Richard and Melissa Tulipan. Permission to erect one-story addition 5 by 22.9 and two-story addition 20 by 34.6 irregular, leaving side yards of 11.7 feet and 10.4 feet instead of required 14 feet each, total side yards of 22.1 feet instead of required 28 feet, and floor area ratio of 30.5% instead of permitted 25%, to leave chicken coop having rear yard of 0.4 feet instead of required 10 feet, and to use dwelling for two-family, family use only pursuant to Islip Town Code Section 68-419.1. Residence B District, south side of Victor Street, 133 feet east of Grundy Avenue, Holbrook.
Good evening, board members. James Apka from Todd O'Connell Architects, holding offices at 1200 Veterans Highway, Hopog, New York, 11788. We're here tonight requesting application for additions and alterations to existing one-story residence, so the owners can have their elderly parents move in with them with medical needs. We're requesting reduction in side and aggregate rear yards and FAR variance.
What does the neighborhood hold as far as the variances that you are seeking?
The variances we're seeking are in line with what the neighborhood was built with. We're actually not making the side yards any worse. We're building in line with the existing dwelling on the side and aggregate side yards.
So, help me out. You're continuing what's existing,
Correct, we're continuing existing setbacks on the house.
and so you're just rebuilding it?
We're adding a second floor addition,
Okay.
which keeps in line with the existing side yard setback.
Then help me with respect to the FAR. You're seeking 30.5.
We're seeking-
We like even round integers on this board. Why can't you build 30 unless you tell me the neighborhood holds?
We did design the,
No. Tell me what the neighborhood holds.
I
Have we
would have to,
granted 30.5 in the past?
I would have to refer to Nicholas for the answer to that.
Planning, can you help us out?
Nah, I can't really help out with that one.
Can't
Okay.
help him out.
You know what that means?
That means we're at 30% for FAR. And in saying that, would the staircase be taken away from the beneath as we spoke about in the town code?
What we spoke about? We haven't spoken
I'm
about
sorry.
anything.
In the town code, it states staircases do not count towards the FAR, so can I remove that from my equation?
How you calculate the
The
FAR
area
auto
underneath the
determination?
staircase, yeah.
30% is what we're
30% it is.
proposing.
All right.
How about the chicken coop? Can you move that?
Chicken coop will be removed.
All right, so,
Did you speak to the chickens?
They're gonna stay there until it gets removed.
any other questions from the board? No. Planning, anything else?
Be removed.
Is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Are we doing anything with the chicken coop, or?
We're denying the chicken coop and 30% on the FAR.
All right, I'll make a motion that we deny that portion of the application. With regard to the chicken coop, we deny the application for an FAR at 30.5%, but grant it at 30% and grant the balance of the application.
Second.
Second, all in favor?
Aye.
Thank you. Have a good night.
Application number 528-26, Thomas Messina, permission to leave one-story addition, 7 by 9.1 irregular, having front yard of 22 feet instead of required 30 feet. Residence A District, west side of Grassmere Avenue, 413.77 feet north of Shore Drive, Oakdale.
Your name and address?
Thomas Messina, 82 Grassmere Avenue, Oakdale, New York, 11769.
Okay, any questions from the board?
No question.
Planning,
No
any
question.
comments?
Just to say that the same property came before the board in '85 for a front yard of 22 feet for a dormer.
And it was granted?
It was granted.
Okay. Is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Danny?
Oakdale. Dan.
Okay, a second, please.
Second.
All in favor?
Aye.
Application's granted.
Thank you.
Application number 529-26, Anne Marie Panagos, permission to erect second-story addition, 17.6 by 35.4 irregular, leaving side yards of 12.3 feet instead of required 14 feet each, total side yards of 24.6 feet instead of required 28 feet, and floor area ratio of 33.1% instead of permitted 25%, modifying condition imposed as part of ZBA number 519-86, to leave patio and driveway on side property line not having required setback of 4 feet each, front yard occupancy of 41.09% instead of permitted 40%, and shed on rear property line not having required setback of 2 feet. Residence B District, east side of Oak Neck Road, 40 feet south of 4th Street, West Islip.
Anne Marie Panagos, 340 Oak Neck Road, West Islip, New York.
Planning, do you have any comments on this application?
Yeah, so one of the things that obviously is going to stand out here is the condition imposed as part of the ZBA decision from 1986. This lot was created as part of a subdivision back then, and at the time, the board conditioned the new house as being specifically either a Cape Cod or a low ranch house. They, I suppose, at the time considered that to be keeping within the character of the neighborhood, and anything higher would not be in the character of the neighborhood. Whether or not the current board agrees with that condition or not, that would be obviously up to you, but that is the condition in question here. As far as the FAR is concerned, it's very much a mixed bag on that front. I think it's higher than what the neighborhood seems to be holding for the most part, especially considering this is not an undersized lot, and most of the ones that are a little over 30 are 6,000 square foot lots rather than 8,600.
Dick, would you say the neighborhood holds 31-ish at the outside? I know it can be tight in that area, but I don't.
Yeah, it's a
we've never
weird one.
granted
There's a lot of
33.
different lot sizes in the area, so this happens to be one of the ones that are, I think it is 31 is probably not out of bounds for the area, yes, I would say.
What do you think about the
Did you
condition?
understand what we're saying?
Not really.
The FAR, okay, the foot-to-air ratio, we have allowed up to about 31. The code says 25. We have allowed, as we've interpreted, as we're entitled to do, 31. We don't have any 32s or 33s, so you're
Well, I wouldn't say
outside
none.
relative to the size of the property. So you may have to, well, the rest of the board chimes in, bring it in at 31 max.
It's the nature and the character.
The nature and character neighborhood holds a much smaller. And if we grant that, then somebody's gonna come in with 35, somebody's gonna come with 38, and in 5 years, we're gonna look around and say, this looks like Queens. No, Queens is a lovely place. But that's why 31, I think, is the number the board will go to.
How about the front yard occupancy, Mr. McCabe?
We're right on par there.
Right on?
Is there anyone else that'd like to be heard in this matter? No? All right, West Islip.
That's me, yes. Thank you, Mr. Chairman. I'll make a motion that we deny so much of the application seeking 33.1, however, grant 31%, and grant the remainder of the application.
Okay, second, please.
Second.
All in favor?
Aye.
Granted at 31%.
Thank you.
Application number 530-26, Dominic Bertucci, Revocable Trust, Dominic Bertucci, trustee. Permission to leave decking having front yard of 24.2 feet instead of required 25 feet, and driveway having side yard of 2 feet instead of required 4 feet. Residence BAA District, west side of East Lighthouse Walk, 180 feet south of Cedar Court, Kismet.
Good evening, I'm Michael Dunn, architect for
You're really
Dominic
pushing it
Bertucci.
at 24.2, Mr.
I
Dunn.
know. Our office is at 256 Orinoco Drive, Brightwaters, New York, 11718. So we're
Planning, any
asking-
comments on this application?
No, no comment.
Is there anyone else that'd like to be heard in this matter? I'll take a motion, please.
Thank you, Mr. Chairman. I make a motion that we grant this application.
Second.
All in favor? Aye.
Have a
Thank you.
good night, Mr. Dunn.
Thank you.
Just so the board knows, or the audience knows why we're chuckling, he was asking for a variance of 8 inches. So it's not, it wasn't a large variance.
Application number 531-26, MD Rabiul Islam and Hafiza Nasri. Permission to establish accessory apartment pursuant to Islip Town Code, Section 68-602. Residence B District, northeast corner of Parr Drive and Waterview Avenue, Ronkonkoma.
Good evening, Larry Buscemi, Select Permits, 15 Vineyard Way, Mount Sinai, New York.
Okay, any questions from the board on this?
No question.
No questions.
Planning, any
These people
comments?
here, they're not for me?
They're all,
Not today.
We should
Is
ask.
there anyone else who'd like to be heard in this matter? All right, I'll take a
I have a
motion,
bad
please.
joke.
Make a motion to approve the application for a period of 3 years.
second.
All in favor?
Aye.
Thank you,
Application's
have a good
granted
night.
For a period of 3 years.
Application number 17-26, adjourned from January 6, 2006. Matthew Allen Sanchez and Sarah Esther Kim. Permission to install above-ground pool leaving front yard on a through lot of 25 feet instead of required 60 feet, and side yard of 15 feet instead of required 25 feet. Shed leaving front yard of 15 feet instead of required 60 feet, and pool decking leaving front yard of 15 feet instead of required 25 feet, and side yard of 11 feet instead of required 15 feet. Residence BAA District, west side of Sexton Walk, 261.18 feet south of Fire Island Lighthouse baseline, through lot to Compass Walk, Robbins Rest.
Good evening. My name is Nicholas Fluger from Bowler Fluger Architects and Graham Associates. We're at 256 Orinoco Drive, Brightwaters, New York, 11718. So since the previous hearing, we made some changes to the proposal. I can run through the changes real quickly.
Please.
So the pool, the secondary front yard, we went from 15 feet in the previous proposal, now we're at 25 feet. The shed, the secondary front yard, went from 10 feet, now we're at 15 feet. The deck side yard went from 10 feet, and now we're proposing 11 feet. Also, a significant portion of the side of that deck is only 4 feet wide. That's right adjacent to the pool. We also reduced the overall decking about 700 square feet. The shed design changed a bit, where we actually have a canvas covering that's extending over the southward, extending southward over the deck. And the shed is further from the north side of the property, the easement side, and also further from the secondary front property line. And the pool was also made smaller by about 60 square feet. So overall, we kind of brought everything in, with the comments that the board had, and also working with Nick and planning.
Okay, thank you. Planning, any comments?
We discussed this application together on many occasions, so I think what's now being proposed is more in line with what I would be in support of.
Okay. So you're in support of it?
Yeah, that's specifically because a lot of this is due to the secondary or the through lot front yard, which in this case is Compass Walk, but it's kind of overlooking the federal lands there. 25 feet in many of these cases actually would have been conforming otherwise, except for due to the fact that they have the right of way there.
Gotcha. Is there anyone else that'd like to be heard in this matter? All right, I'll take a motion, please.
Thank-
I'm sorry, I'm sorry.
Nope.
Someone?
All right, thank
All
you,
right.
Mr. Chairman. I'll make a motion, we grant the application.
Second.
Second, all in favor?
Aye.
Aye, application's granted.
Thank you, have a good night.
Application number 532-26, James Rosa, permission to leave driveway and wall having side yard of 2.1 feet instead of required 4 feet. Residence B District, west side of Bayview Avenue, 202.5 feet north of Maple Street, Islip.
Mr. Chairman, members of the board, William Garbarino, 40 Main Street, Sayville, New York, for the applicant. I believe this application, in the balance of the equities, meets all the requirements of 267B, and I request that you grant the application.
Planning, any comments?
No comment.
Is there anyone else that'd like to be heard in this matter? Take a motion, please.
Nice presentation, Mr. Garbarino. Make a motion, we
Thank
grant
you
the
very
application.
much.
Second.
All in favor?
Aye.
Aye, application's granted.
All right, you want me to recuse now?
Do we have anything else?
Nope.
No read-ins? Want to do the read-in?
Well, I know.
Yeah.
Do you want to?
Yeah.
Oh, okay. So just a administrative item, we have 32 accessory apartments to renew for a period of 3 years.
Motion.
Second.
Second, all in favor?
Aye.
And before I call the next case, Mr. McCabe?
Yes, for reasons made known to the chair, I'm going to recuse myself in this application.
Okay, we'll miss you.
You're leaving?
I'm leaving you, Bill.
Thank you.
Enjoy your evening. Sure we will.
Application number 533-26, Detty Abner and Laurel Eastman. An interpretation is requested as to whether boarding constitutes a permitted accessory use to a parochial school within a residence AAA district pursuant to Town Code Sections 68-45 and 68-48. Residence AAA district, west side of South Saxon Avenue, approximately 1,072 feet south of Montauk Highway, Bay Shore.
All right,
Yeah, no worries.
we're gonna take a few minute recess.
I'm gonna hit the head.
Easy, thank you. It's a pleasure. Give it. Yeah, no worries, no worries. Good, sir. How are you? Hey, how you doing? Steve Bertolino. You think I was calling anybody back today? Yeah, we're gonna make a statement. I can't, I don't have an extra one. I just handed them all up. You know what? I can give you. I can give you this without exhibits.
What are you going to read?
That whole thing.
You're going to read this whole thing? Okay, perfect.
It's, this one's slightly different. This one's for the live version, that one's for the submission version. But it's the same.
Okay, great, thanks.
631-831-0752. All right, thanks.
We'll be good. Hey, how you doing? All right, good.
Empty seats over here if you need a seat. Excuse me. You got empty seats over here. Wherever you want to sit. Bruce, you got in? You got in?
Oh, you did?
Do you need a card? No? You need a card?
It's so funny. It's so funny how they either love it.
You got a good smile.
And I'd say 2 years ago we started letting take pieces. Yeah, I think it was the summer.
These have. Announcement? Okay.
Yeah.
Sorry.
You did first.
You ready? Once your presentation's over, then I can switch to stream. Yeah, it is.
was, but you missed it.
Uh,
A little bit. I got my
Right.
own list.
Good evening, ladies and
It's very
gentlemen.
short.
Okay, that's,
That's what kind of night we're in for.
yes. I just, several things. We'll need everybody to be seated, please, if you can find a seat. Just, I will momentarily. Okay, we still have some people coming in. Well, that's what we're trying to find out. Maybe IT can help us. Can the people in the back hear me? All right, hang on. Yeah, right. I can't hear you. Well, maybe we'll ask IT. Hang on. All right.
Just said he's got IT working on it. You gotta be on the station, okay? It's a big room with a lot of people.
Ladies and gentlemen, please, we're working on it. What we're trying to do is make sure that everybody can hear us. So we're having IT, you can't see them, they're behind the curtain, work on it. So that's the first thing. Somebody asked me if I would identify myself. My name is William Wexler. I'm one of the board members. So okay. Yeah, would you, just a moment. Okay. All right, can people hear me now? All right. In the back, can you hear me? Okay, I see the affirmative sign. I'm going to ask Mr. Bertolino, will you just do a test to make sure that mic is hot, please?
Test, test, test.
No.
The man with the camera.
Test.
It's from Newsday. The woman standing next to the
Test.
microphone is from
First time somebody couldn't hear you, Mr. Bertolino.
I'll speak louder.
All right, is IT, can you raise? All right, just a minute, please. All right, Mr. Bertolino, will you test?
Testing, testing.
Okay, all right. All right, now that we have IT straightened out, thank you very much. Obviously, there are a lot of people concerned about this issue, and in a democracy, that's what we have. People come out to be heard. However, we're going to ask just several basic things. First is that we're going to have several attorneys make presentations, and then people who wish to be heard, our chairman, Mr. Italiato, will be calling on you and running the meeting. The only thing that we ask is that please don't clap, don't applaud, because it just slows down, people can't hear. Everybody will get a chance to be heard, okay? That's all we ask. And if it's a long night, we're all good till about 4 a.m. And then the union says that it's overtime for us, so, okay.
Not to repeat.
Yes, and also we're going to ask one other thing. A lot of people will want to speak, and you are welcome to be heard. However, after a while, we get it, and people will say the same things over and over. You can, but it becomes a long, droll evening. And we'll get it, but everybody who wants to be heard may be heard. I'm going to turn the hearing over to our chairman.
Okay. Mr. Bertolino?
Yes. Mr. Chairman, members of the board, Madam Secretary, just some housekeeping items. I had submitted through email today to Mary Pissarro some documents. I handed up copies to each board member as well as an additional copy. I did make some corrections after I submitted that, basically ministerial, some quotations for code, if I can have the opportunity to correct that and submit that tomorrow. This evening, I also handed up a flash drive, which contains a video, which I presume my counterpart, Mr. Campanelli, will be hopefully putting on the screens a little bit later. Lastly, if I can address two more things, one with you, Mr. Chairman, or with Ms. Pissarro. We had discussed previously the order of speakers, and I would just like to be able to appoint, if possible, the first 4 or 5 public speakers who I believe are going to speak on issues that I believe the board needs to hear and will support our application. And then,
So they would be speakers number 4 through 9?
yes, if you're not, I'm saying public speakers.
Got it.
The
Okay.
total would be probably 3 or 4.
That's after Mr. Bifulco.
That's correct. And I would like the opportunity for any rebuttal from Mr. Bifulco if the opportunity is necessary.
As long as we give him the same.
Thank you. And then there's one last thing. If I can just address the crowd for a moment?
No, I don't think you need to do that.
Okay.
No, just please make your application.
Good enough. So, good evening. I'm not quite sure if this board is hearing this application as the applicant direct, or if in the back and forth communication with the board through myself and Madam Secretary, whether or not this board is hearing this as an appeal. I know it was originally submitted in the alternative, whether it was an appeal to a zoning letter that was issued January 21st or 2026, or if it was being heard as a direct application.
This is an appeal of the determination.
Okay, just wanted to be clear of what we're doing. So, on that note, as we all know, an attorney, Samuel Bifulco, filed a zoning inquiry form requesting a zoning determination that the proposed boarding school does not require any discretionary approvals from the town of Islip, and a boarding school is a permitted use within the AAA zoning district. In response to this inquiry, Dan Burgos, a building plans examiner, who we all know and love, even though his name comes up a little bit tonight, or his letter, in pertinent part wrote, "Boarding is permitted as an accessory use to a principal parochial school use, provided that such use is incidental and subordinate to the primary purpose of education," unquote. My clients disagree, as do I, that Mr. Burgos' interpretation of the code is accurate. We believe that Mr. Burgos did not have the authority to make such a determination, which required an interpretation of the zoning code, which only this board has the authority to do. I represent Dee Dee Avner and Laurel Eastman on their application appealing this determination, as we just established, for the interpretation of the zoning code on the question of whether a boarding school is a permitted use, either directly or as an accessory use in the AAA residential zone. I'm requesting that this board issue a determination or a decision that a boarding school of any kind is not a permitted use in the AAA district, whether as of right or as an accessory use, and that a change of zone is required for such use, or at a bare minimum, that a special permit from the town board is required, as would be required if this was the less restrictive Business 2 district under Town Code 68-287. As it turns out, Mr. Bifulco submitted his application in his personal name, but on behalf of his client. The United American Muslim Association now has an application before the planning board to operate a boarding school. Part of that application seeks a relaxation or a determination of the parking determinations for that boarding school. Mr. Bifulco sets forth that the parking requirements are not specifically set forth by the town. It is apparent that Mr. Bifulco, and perhaps the planning board as well, is relying on that zoning letter in the impression, mistakenly I believe, that such an intensive use permitted in the ISIP's most restrictive residential zone, the AAA. It is therefore imperative that this board expeditiously decide this issue, publish its decision, so that any further inroads to open this boarding school are quashed. We don't believe that there's any right to open this school in this zone, and the zoning code, as it exists, does not allow it. The proposed use of the premises as a boarding school, Mr. Bifulco submitted a memorandum of letter, or the letter of use, as I'm referring to. The planning board, he submitted that to the planning board, outlined the proposed use as a boarding school, and therein set forth the reasoning for the planning board needs to determine the
Mr.
parking
Bertolino, will you
calculations.
slow down? I see our stenographer trying to keep up with you.
She usually does.
Well, you're pushing it.
Kind of important this time.
You good?
I think you want a clean record.
I do.
Slow down.
Please slow down.
Okay. Thought you wanted to go home early. The letter of use is interesting because it highlights so many of the issues that my clients declare show decisively why no such permitted use as a right. Mr. Bifulco's submission rests on the existence and the internal layout of the existing building, as the letter of use states that the applicant intends to utilize the existing building and the site with minimal changes. That on the second floor, 24 existing dormitories will remain unchanged. That the third floor will contain 23 bedrooms for administration, faculty, and staff who reside on site. It concludes that the proposal involves minimal changes to the building and site, aligning with the property's historical use. As to the history of the premises and the structures thereon, the letter of use offers only an appearance. Mr. Bifulco's words are, through investigation and due diligence, it appears that the structure has been historically used as a seminary and at various points a boarding school. Mr. Bifulco cites no certificate of occupancy, no permit, and no grant authorizing the boarding school use. Mr. Bifulco cites no provision of the town code on which the configuration of an existing building can be the basis to authorize a proposed use. The letter of use addresses two things: the accessory use theory on which the zoning letter in Mr. Bifulco's application depends, and which the code own text forecloses. Two, Mr. Bifulco's reliance on the existing building, including its layout and history, which the code's text and the town's certificate of occupancy or occupancy record also negates. The zoning letter can be digested in a single sentence: that boarding is permitted as an accessory use to parochial school, quote, provided that such use is incidental and subordinate to the primary purpose of education. The zoning letter, like Mr. Bifulco, cites no provision of the code for that proposition. The basis of the proposition depends on the word accessory. And so I set forth below what the code requires before that word can apply, and the errors in Mr. Burgos' use and reliance on it in drafting the zoning letter. Before I get to the accessory use, there's a threshold problem in the letter of use. It does not describe a school with an incidental residential component, but describes a single use in its own words. The proposed use, known as the Bayshore Academy, contemplates a boarding school that will provide religious and secular education to 120 male students, unquote. That's what he says it is. I'll read it again, not in full. The proposed use contemplates a boarding school. The proposed use contemplates a boarding school. Mr. Bifulco twice acknowledges in the letter of use that the town schedules contain no entry for that use, writing that the parking calculation is not enumerated in the town code for the proposed use, and that a boarding school is itself not listed in the town's table of minimum parking requirements. A use cannot be an accessory to itself. If Mr. Bifulco is citing that the use is a boarding school, how is it an accessory to itself? It is either a boarding school or it's an accessory to something else. If the proposed use, as the letter of use sets forth, a boarding school, then a single use does not appear on the residence AAA use list, and 68-47.1 disposes of it. That's where it says any other use not specifically listed is not allowed, shall not be allowed. The accessory use.
Mr. Bertolino, is a school permitted to be
A
built
parochial
there?
school is permitted, that's
Okay,
correct.
So the parochial school can be built there, correct?
Yes, it can.
And I think we are reading the call of the calendar, and what the issue is before us, and the sole issue before us tonight, is whether or not a dorm is an accessory use to a boarding school. Yes? A parochial school.
That may be the call of the meeting, Mr. Wexler,
But we have to go by the call of the calendar.
Okay, but
The call of the meeting, it's not what you may want it to be. We have to follow the law. That's in the call of the calendar, or the call of the meeting. So the first question that I have for you is a dormitory an accessory use to a boarding school?
No.
Or parochial school? It's not?
No.
So,
Not under the town code, Mr. Wexler.
okay, so the town code, let me ask you some questions, so we can focus and figure out where we're headed. We understand that town code 68-45 permits a parochial school, correct?
Agreed.
Okay, and then you know the language about customary, incidental, and subordinate. I think that's going to be the thrust of tonight's discussion, correct?
Correct.
And the issue is, and again, I want to hear from, we all want to hear from everybody. The question is a dormitory customary, incidental, and subordinate to the school? That, to me, is the issue. And correct me if you think I'm wrong.
I agree with you that that is one issue, but as I started the hearing, I questioned whether this is an appeal, and I was told it is an appeal. That's how this board is treating this. And if it's an appeal, then we have to address what the appeal is of. And the appeal is of the application for the use as a boarding school. Those are not my words. Those are Mr. Bifulco's words set forth in his letter of use to the planning board.
So this hearing is an interpretation of the zoning board determination. The hearing tonight, yeah, this hearing tonight is for an interpretation of the zoning board determination.
Yes.
I'm sorry, the zoning.
I don't
The
think
zone-
it-
I believe you meant the zoning letter, Mr. Italiano.
Yeah,
Yes,
Because the zoning board hasn't made a determination.
correct, I'm sorry, yeah, the zoning determination.
We understand each other, just
Yes.
make sure the record is clear.
Along those lines of understanding each other, you were phrasing a question before to me and the board, whether this was an appeal or an interpretation. Well, those are the two choices you gave us?
That's correct.
It's an interpretation pursuant to New York State town law. This board has interpretive powers. That's, so maybe we misspoke in answering you?
That's, okay.
Okay.
In the end, Ms. Pissarro, Mr. Chairman, and Mr. Wexler, I think it all comes down to the same thing. You know, what you believe the issue to be and what we believe the issue to be is the same. But just jumping right to the end without understanding the full context of the code, because the code was not written in a vacuum. The code was not written with one singular provision. The code was written with multiple provisions within the same 68 chapter, but over multiple subdivisions within that chapter. And as I go through my presentation, hopefully it will become clear that there is not a single, not one, permitted use of a dormitory with a parochial school listed. There are instances, and if you want me to cut to that, I certainly can. There are instances where after a town board public hearing, which we have not had on this application, will allow certain dormitories to exist. There are instances within the town code that do allow, and the one is the PDD-EC in Central Islip, that does allow on an educational campus, housing for faculty.
Because the code specifically allows, in that code provision, for housing for students and faculty?
Yes, I believe it's, give me one moment. Should be 68, 324, A3, A4, and 6, which, again, my understanding was specific to the PDD Central Islip Corridor, which is DeCalton Avenue.
But the point is that at some place in the code, they do distinguish between a school and a boarding school. Or
No, Mr. Nicolia, what happens within the code is that the code is silent, if you will, in the most restrictive AAA residential zoning district. There's no mention of that. And there's no mention of a lot of things within that provision, right? It doesn't talk about swing sets. It doesn't talk about vegetable gardens, if you will.
No, I'm aware,
Right.
yes.
But the code doesn't talk about those anywhere else either, because those are accessory
But
uses.
in this instance, the code may not talk about boarding facilities in the AAA code, but it does in other areas of the code. Is
It
that what you're
does. It
saying?
talks about it
Okay.
in the business district, in the business 2 districts. It talks about it in certain other districts that was specifically laid out. If there were college campuses, if there were other educational facilities, and it specifically requires, in most instances, a town board hearing. The planning board is allowed to hear, under those commercial districts, the town board, I'll say relegates, if you will, to the planning board, the uses of an educational institution, whether it's a private school, parochial school, in those districts. However, the town board also carves out and excludes, it severs, excluding dormitories and similar residential uses in those provisions. So at each step that the code goes, and you have my memorandum, which I know I'm relying on, and I'm presuming if I'm cutting through all of this, you're going to rely on it as well. As you get through those sections, those provisions of the town code, you will find that in each instance that any type of dormitory is allowed, it's after a town board hearing, not zoning, not planning. When the town drafters of the code did allow for the planning board to hear if a educational use was permitted, it specifically cut off the dormitories and said, no, you can't talk about this. You can't address this issue. So I view that, and I think a reasonable person would view that reading of the code in its entirety, you know, as it's applicable, as saying the town board reserves for itself the sole right to determine when a dormitory, when a use of this magnitude.
Where in the town code does it say that that right for a dormitory is relinquished or part of the town board's authority? I don't know that section.
It's not that it's, it doesn't specifically say, Mr. Wexler.
Okay, let's just establish that. You keep saying the town board, the town board. It doesn't say that. You're saying
No,
you
but if-
can read it and infer it, but you keep making it sound as though there is a town board section that's lost on us. There is no town code section that says what you're saying. You're saying inferentially, if you look at the code, it's a swing set or a koi pond. So there is no, like, we just need to get that straight. There is no town code section that you can point us to that says only they can grant a dormitory, correct? Unless there is, tell us. That's why we have these hearings.
Mr. Wexler, as you know, you and I do this dance quite often, and this is one of those times that
No, I'm not asking for a dance.
I'm very pleased that this board consists of attorneys.
I know,
Because
I'm
yes,
only
we do.
asking.
I'm going to answer.
Mr. Bartolino, just give, please. No, I know.
Ma'am,
No, ma'am,
Ma'am.
ma'am, ma'am.
ma'am, we're having a debate.
Okay, no, the rules are the board may ask questions. So, those are the rules, we're going to follow them. My question is, I just want a section. I just want a section of the town code that supports what you're saying, just numbers. Give me the section number.
Mr. Wexler, that specific language verbatim does not exist.
Okay.
No, you are correct. Nowhere in the town code, in the zoning chapter, does it say only the town board can hear this. It is an inference. But one must make an inference when interpreting the statute. What is going on here is the question that needs to be asked by this board when they're interpreting the code. What's happening? And when you see throughout the chapter, when you see that the only time a dormitory can be used, and it's usually related to a college or a university, right? Those are the only times that it's brought up, never in a residence A, B, AA, AAA. You don't see them. But when you do see them, the town board says, we have the purview to have a public hearing. And when you do see the provisions in the code that say the planning board may address an educational institution, the code explicitly cuts off the review of dormitories. So the logical inference, Mr. Wexler, I believe, is that the town board reserved for itself, even though the language is not verbatim within that code, it reserved for itself the sole right to determine when you can have that. And that's part of what we're saying here. I said it in my opening statement, if you will. We're asking and we're telling, from our perspective, that that zoning letter issued by Mr. Burgos is improper. He doesn't have the authority, only this board does, to make that determination, determination what the code means and what it says. Do we need to make inferences? Yes, we do.
So this board has the right to make that determination and interpret the code.
In my view, and I believe in yours too, because you've said it to me countless times in the past. I've heard you on that dais say that.
Okay, so we can make the determination. We don't need the town board.
You do not need the town board.
Okay.
And if you took that from what I'm saying, I apologize.
No. You know what you're doing.
I'm trying.
And no, we both are. Go ahead, this is interesting.
All right, so let's get back to the accessory use where I was, if that's okay. So the relevant code sections for an accessory use. 6845B permits a public or parochial school. The accessory catch-all 6848A1J, I quote, permits, or unquote, permits, quote, other customary accessory uses, structures and buildings, provided that such uses are clearly incidental to the principal use and do not include any activity commonly conducted as a business, unquote. That's the catch-all. The catch-all imposes two requirements, and a use must satisfy both. It must be customary. What does that mean? As you questioned a moment ago, is it customary? My colleague and fellow attorney, Andrew Campanelli, will be addressing that, following myself, as part of our presentation in chief. It's the kind of use habitually found together with the kind of principal use the code permits. The code in AAA does not permit a boarding school. In a district of this character, you don't see it. Second, the use must be clearly incidental. Yet Mr. Bifulco's own memorandum, his letter of use, doesn't say we want a boarding school as an accessory use. It says the proposed use is a boarding school. Doesn't say an accessory, not my language, Mr. Bifulco's language. And that's what we hear about. The zoning letter's first error is that it proves the wrong element. Its reasoning is that the boarding serves the school, and that a use which serves a permitted use, therefore, must be an accessory to it. Doesn't make much sense to me. It speaks only to the relationship between the two uses. It says nothing about the use being incidental, which is what the code requires.
But isn't a boarding school, isn't the dorms incidental to the school?
That's why we're here.
Well, no, but I'm asking you, listen, I know people who've gone to boarding school. I can name 10 of them at the top of my head. I mean, you have boarding schools throughout the Northeast. You have them in New York. You have them in Suffolk County. They have dorms. I mean, you have people who go to boarding school at Choate or Andover or Exeter or Stony Brook Prep. They have dorms, and there's a test that we have to use.
Yeah.
There is
Mr. Wexler, this
that
was...
we have to use whether or not it's incidental. I'm just saying, how is a dormitory not incidental to a parochial school that has boarding? I can't get around that.
let's take customary first, and
Sure.
I'm stepping on Mr. Campanelli's toes for the
All
moment.
right, I'll defer. Do you want to defer that to Mr. Campanelli?
Yes, do you want to address that now, or do you want to
No.
circle back?
Whenever you want in your presentation.
Okay. That
I
is
see
his...
Mr. Campanelli saying yes, he's nodding, so we'll do that.
As you know, we're partners in crime here, and that's his section. He drives the getaway car. I just
Fair enough.
show up. All right. With that being said, the code does not ask what serves what. The code asks what is the land used for. Mr. Bifulco's letter of use provides the answer. It's an institutional residential occupancy. He doesn't say a parochial school with an accessory boarding facility. It's not what he says. He says it is a boarding school. There's a distinction there. The distinction goes to the incidental, putting the customary aside for the moment. The floor space, 47 sleeping rooms and their supporting facilities occupy most of the building. By the time the residential occupancy runs 24 hours a day, 7 days a week, throughout the academic term, while the instruction runs approximately 6 hours a day on weekdays. By head count, approximately 140 students stand against approximately 10 commuting teachers. In this instance, the residential use is not subordinate or incidental to the school. It is the dominant use of the property, and the dominant use cannot be clearly incidental, as the code requires, quote unquote, clearly incidental to anything. The drafters of the code know that the code has content. The first accessory on the district's own list is a private garage. The private garage has limitations. It says, provided that the gross floor area of the garage space does not exceed the ground floor area. I was here a couple of weeks on that issue. The same list permits a thrift shop as an accessory to a church, and it caps it at 10%. 10%. Those are examples of incidental, customary uses that are incidental to something else. A gift shop. Indeed, the only place that you see a residential structure would be a parsonage, where they allow a parsonage on there, and it must comply with the dwelling restrictions of that particular zoning code. A garage measured by the living area to the dwelling it serves, a thrift shop capped at 1/10 of the building. The zoning letter reads subsection J, which again is your catch-all phrase, of the same list to accept, without limitation, sleeping quarters occupying most of the building. That cannot possibly make sense.
can I just ask you a question?
Sure.
You're reading specific code sections. There is no specification in this code section as to size. There is not. There are, when you're talking about accessory structures, you're talking about garages, you're talking about 10% in a parsonage. Yes, the town board has determined we will put a percentage. With respect to this accessory use, whether it's incidental, there is no percentage, there is no square footage, and the courts, hang on, and the courts have said, in fact, Islip has made a lot of law in this area. And the Baker case, the second department, I'm sure you're both familiar with it, the Baker case is very specific, and we have to follow the higher courts. And that case, they said, if the town board or the town code does not put a specific percentage, then, and this is the wording of the Baker case, and I could put the site on the record because I know it, 20 AD 3rd 522, second department, 2005. The specific word said, and they've reversed the town of Islip, I know that very well, that the town cannot, and the word they use is engraft, E-N-G-R-A-F-T, a number. So you are giving us code sections that have written in a specific number, which I agree. There is no number in this section, and boards such as Islip, ZBA, have been reversed when you engraft a number. So there is no number, there is no as to square footage or percentage. We can't make one up unless you have case law that says we can graft.
Couple of things.
Sure.
Once again, I'm going to defer to the brains of the operation,
All right,
Mr.
fair enough.
Campanelli.
No, I want to hear it from Mr. I'd like to hear it from Mr.
Number one.
Campanelli.
Number two, I appreciate what you're saying, but in the beginning of what you said the code in defining limits of a garage or defining limits of a gift shop specifically set forth what the percentages, what the numbers can be. But those were specific accessory use listed items. Nowhere in the code is a boarding school listed as an accessory use. And therein lies the distinction. You want to jump to step 2 and say, well, we can't put a number on it. You forgot about step 1. This doesn't exist as an accessory use. It's not permitted. It's not there.
If it's incidental, it is.
Well, okay, so what's incidental then, Mr.
Let's
Wexler?
just so the record is clear, the town code is very specific. It says customary, incidental, and subordinate. If those 3 terms apply, then it is accessory. So what we have to look at is it customary? And again, I'll defer to, or I'll let you defer to Mr. Campanelli, but down the road, we're going to have to, and as we narrow this, we're going to have to address, you keep saying it's not allowed, it's not allowed, it's not allowed. I don't read the code as that. Let me just finish. The code says if it is allowed, if it's customary, incidental, and subordinate. So those are the 3, that's what the courts and that's what the town code, and I believe that language you see in many town and village codes, okay? Customary, incidental, and subordinate.
Not subordinate.
And, pardon me?
Not subordinate.
Okay, customary and incidental.
Yes.
So, but it's also, the courts have said subordinate. But I think that's the issue. So when you keep saying that it's not allowed, it is allowed if the applicant, and I don't know if they can, meet that criteria.
I disagree.
Okay.
Because, Mr. Wexler, you're saying it is allowed. And maybe you didn't hear me before when I said the code.
I heard you.
The code itself, as we infer from the entirety of the code, not one snippet, the entirety of the code as we read it as attorneys, we can interpret it. What's going on here? And when the code specifically carves out dormitories and boarding schools and puts them in other chapters, in other sections of this chapter 68, and says, this is when this use is allowed, and these are the conditions upon which we will allow it, how then does one bypass all of those public hearings that are allowable under the business zones and the commercial zones? How do we then take that use, plop it into the most restrictive residence zone that the town has, the AAA, and allow it because we call it an accessory use? Well, that's wonderful. We allow a library in the AAA, Am I allowed to build a dormitory next to a library to house the librarians? I don't think that would be permissible. But please.
Please, no, please, no.
Please.
No,
Let's stand, hang on,
there'll be no grandstanding.
we can't have that. No, we're not,
Please,
Okay.
ladies and gentlemen, please. The point, Mr. Wexler, respectfully, the point is, you cannot take an accessory use, or you cannot take an item, forget an accessory, you cannot take something as a use that's defined throughout the code in other provisions, pull it out, throw it in to another section, call it an accessory use, and say, I'm allowed to do it. Now, I'm not the one that put forth to the town of Islip that the proposed use was a boarding school. I didn't do that. Mr. Bifukal did that on his own accord. I'm simply translating what he put in his letter of use, applying it to the code, and saying, how is this permissible? Now, I jumped 2 pages, so maybe we saved some time, but the zoning letter's third error, it supplies no limiting principle, going to your Baker case. If 47 sleeping rooms and approximately 140 continuous year-round residents are incidental and subordinate, which is the language you're looking for, to a 6-hour school day, then I ask this board, what would not be? Can I put 100 rooms and 400 people? Am I allowed to just triple the size of the dormitories and say, well, it's an accessory, it's incidental, it's subordinate? At what point does incidental and subordinate have a meaning? I don't know what that number is. I don't know if it's 24 rooms or if it's 47 rooms. What I do know is that it's not an accessory use in any way, shape, or form under this provision of the code. It should never be allowed because you can't pluck it from another area of the code and put it in this and say, hey, we can do this. Moving along, if I may. I just cut down 2 pages. I'm going to bypass it because I think you get
It's
the
very
point.
unlike you, Mr. Bertolino.
I know, but, I'm trying to be
he's
fair.
got
There's a
his
lot of
back-
people behind me.
He's got his backup.
And I got my backup, my wingman. Anyway, a couple more things. AAA zoning is more restrictive, not less. We know this. Under the interpretation set forth in the zoning letter, the identical use enters residence AAA, the most protected residential district in the town, with no public hearing, no permit, no conditions, so long as we attach it to the school. Think about that. It's what I just finished saying, skipping over 2 pages. All we have to do to get a boarding school in a residential, the most restricted residential area, is call it an accessory? To me, that makes no sense. When the town board, maybe not this board, maybe it was a prior board that drafted that language, specifically gave us avenues. And as attorneys, we come before you boards on those avenues, and we ask for permission to do certain things. And when we do that, we say, I'm coming down this road, because this road has the signs that say, that's how you get there. AAA zoning doesn't have that sign. There's no arrow that says this way. Those arrows can be found in the commercial districts of the town code, but they can't be found in the AAA. And you can't simply attach it to subsection J and say it's an accessory use. To me, that doesn't work. It just blows the code
I'm going to
apart.
order this record only because for 17 years, I've heard you, Mr. Bertolino, ask us to expand the town code.
I got to tell you, Mr. Wexler, this is the first time I'm in opposition mode.
Yeah, okay.
Well,
no,
maybe
no,
one
no,
other
I-
one.
I'm enjoying this.
Usually they're against me,
Yeah,
you know
of
that.
course, I'm enjoying this.
All right, let's get back to the issue at hand. Bottom line, Mr. Wexler, members of the board, it comes down that the code permits an educational institution, including parochial colleges and all, after a public hearing in front of the town board. Sometimes you can get an educational use in front of the planning board. But you can't just get it from a zoning letter. As much as we love Dan Burgos, whatever avenue he went down to issue that letter, I do not know. But what I do know is that it's not his purview to make the determination, it's this board. You certainly can't make the determination of what the code means from a staff letter. The end point on every turn that the applicant, if I'm not the applicant, every turn he makes, we can shoot it down by a section of the code. If it's a second principal use, if the primary use is a school, as Mr. Wex was playing devil's advocate and saying, well, can we put a school there? Sure you can. We all know that. You can put it there. So what then is the boarding school? Is it an accessory? There's no pathway for that. And I think I've just shown to the board, at least I believe I have, that you can't pluck from one section and put it in another, call it something that looks like a duck and sounds like a duck, but ducks aren't allowed there. Can't do that. The existing building layout, let's move forward to the next part of it. You're going to like this one, Mr. Wexler. You're in here. An existing structural layout cannot make a use permitted. Mr. Bifulco's reliance on the layout of the existing building in his letter of use fares no better. The code answers the argument in a single sentence. Section 6813 provides, no building or land shall be used, and no building shall be erected or structurally altered except in conformity with this ordinance. The requirement, unquote, the requirement of conformity governs the use of the existing buildings just as it governs new construction. The mere existence of walls, bedrooms, confer no use rights. The lawful use of a building is fixed by the code and the certificates of occupancy that are issued under it, not by the building's floor plan. Imagine if every purchaser of a building in any zone within the town of Islip came to town hall or the zoning board and said, and you'll love it, well, I bought it this way, therefore I'm entitled to keep it and use it that way. I know why you're laughing, and here it goes. Mr. Wexler would either have a proverbial field day or a heart attack trying to explain to each applicant that that's not how
I prefer the
code
field
works.
day.
I know. You love that. I've been here so many times and heard you say those very words to so many applicants. But that's exactly what Mr. Bifulco wants to do. He wants to come before you or the planning board, and maybe we need to move you to the planning board at this point, Mr. Wexler. He wants to step up here and say, I bought it this way, therefore I can use it this way. That's not how it works. You know that, I know that, and every member of the board knows that. Moving on, nonconformity of use does not apply. This is your pre-existing nonconforming use. 6814 defines that legal nonconforming use as any nonconforming, quote, as any nonconforming use which, at the time such use was commenced, was maintainable as a matter of right under the statutes, ordinances, and general rules of law then in effect in the town of Islip. We all know what a pre-existing nonconforming use is. That's the only shelter, in my view, it's the only shelter that maybe, just a big maybe, that Mr. Bifulco can stand on. The problem is, there's a termination clause. It's 1 year. You know that, and I know that. Here it goes. 6815B provides the substantial quote, the substantial, my emphasis, discontinuance of any nonconforming use for a period of 1 year or more terminates such nonconforming use of a structure or premises, and thereafter said structure or premises shall not be used except in conformity with the provisions of this ordinance. And by the code's own rule of construction,
You're saying it was abandoned, the use?
Oh, absolutely.
Okay, yeah, no.
Absolutely. And wait, we're not talking a year here, Mr. Wexler. We're talking decades, tenfold, 20-fold. The town's own certificate of occupancy forecloses any claim of continuity. The certificate of occupancy on file, which I've handed up, the board has access to as well, it was for a parochial school or secular education, was ever issued. Let me repeat that. No certificate of occupancy authorizing a boarding school, whether for parochial or secular education, was ever issued.
Well, it predated the code. It predated the code. It was 1928. There was no zoning board to issue.
That's right. But here's the thing. If you look closely at the certificate of occupancy, you'll see that I believe in 1953, there is a reference to an alteration to be used as a convent. And before I comment on the convent, in 1963, there was construction of a 3-story seminary building. Now, I'm not a religious guy. I've never been to a convent. I've never been to a seminary.
You've never been to a convent?
No. Concert, yeah, convent, no. But here's the thing. The computer's a wonderful thing. You can look things up these days and get a little bit of history depending on where you get it. My understanding is, and I put to this board, a seminary and a convent both require, or how should I say, not require is not the right word, custom and usually require that the person going in is at least 18 years old. maybe they're 17. Generally, you complete your lower education. Maybe for a seminary, it would be on your way to a higher education. But at no point, from my understanding, when you enter a convent, which this property was used for, when you enter a seminary, which this property was used for, are you 14 years old? Are you 12 years old? Are you 8 years old? There's no record anywhere that this property was used as a parochial school, except, and here's the rub, 1967, under the prior code, CAA, which predated the AAA zone, there was a special exception through the zoning board. It limited school use to 20 children with an age limit of 14. And that modest daytime use, no boarding, no overnight. Now, maybe there was some nuns running around the seminary when 20 kids went to class in the morning. I don't know. I wasn't there.
So probably a good time to talk about that entry on the CO. There's 3 zoning board of appeals decisions referenced there. There were 2-year renewals. They don't pertain to this site. This is an unofficial CO, so they pertain to a site that used to exist on Montauk Highway.
I set the wrong CO, or is this an incorrect entry?
It's an incorrect entry. And
Well-
easy enough for me to find out because there's 3 ZBA decisions cited and their physical locations. And as I said, it was 2-year renewal. It was a little bit of a showdown between James Fallon Sr. and Stu McLaughlin.
I remember Stu.
Very
Good
interesting
guy.
case, yes. It was like a home for developmentally disturbed children. And
Well,
it was on Montauk Highway and it's long gone.
Well, Mary, I thank you for that, and I love you even more because, hey, they didn't have any entry on a CO for use of a school. It was a seminary, it was a convent. We can
In
assume.
2012, I think we were told to stop summarizing decisions like that.
Yeah.
So those kind of entries don't appear on COs anymore.
Okay, well, I'm going to gloss over all that anyway because it just supports my proposition that no school use, now, I wasn't going to say none because I thought there was, but now I'll say none. No school use, and certainly no boarding school use was ever there. How do you compare a school for young adults, I don't know, 8 years old to 18 years old? How do you compare that to a seminary where the lowest age, the minimal age is 18, or a convent where the minimal age is 18 for entry, when it's generally for higher education? 2 very different things.
Mr. Bertolino, we can give you a copy of the CO, or did you? Oh, you handed it up to us. I'm looking at the penultimate, or actually the 4th to the last entry, and I'll quote, it says, demolition of 1/2 of dormitory plus utility storage building. They were seeking to demolish 1/2 of a dormitory.
Yes.
Do you agree that there was a dormitory somewhere?
Well, if we have to infer from.
It says, it doesn't say doghouse, chicken coop.
Right. It says dormitory.
Dormitory.
Does it say dormitory for a school? Does it say dormitory for a seminary? Does it say a dormitory for a convent? Because we can all agree, Mr. Wexler, there's no disputing it. There are bedrooms in that building. Those bedrooms were used for many, many years, many, many decades ago. Did they call it a dormitory? I presume they did. Why? Because people slept there.
Yeah, but I don't know if I mean, we all went to college. I went away and I lived in a dorm. I mean, I don't know if a dormitory is associated other than with an educational institution.
A seminary is an educational institution.
And they have dormitories.
Correct. I believe that the reference here for a dormitory is to the seminary.
I understand that.
I mean, it's like you don't go home and say.
46, they reference a school.
So there's reference to a school and reference to a dormitory because they demolished half of it. So I mean, I only associate, and again, I don't know, I only associate a dormitory with a school or an educational. I don't say to my friends, oh, I'm going home to my dormitory. I'm going to my house. So I don't know if that argument supports you, but.
Perhaps I lose that argument, and maybe Mr. Collier is right. You know, is this, again.
How come he's right and I'm not?
You could be right sometimes, you know, but in any event, moving forward, we've got a long night here. let's assume it was a school. I'll concede that point. Let's assume at some point there was a school. The document speaks for itself with respect to the dormitory. I agree, there was a dormitory on there. But that doesn't mean, once again, that you can use it as a pre-existing non-conforming use. That's the section I'm just talking about. The code makes the loss of a non-conforming use a one-way door. A legal non-conforming use shall not be changed unless changed to a conforming use. Moreover, even if a non-conforming use survives, it's confined. It has to be, can't be expanded. It can occupy no more than 25% of the floor area. But most importantly, you lose it after 1 year. Even by Mr. Bofulco's best imaginable theory, the zoning letter's conclusion doesn't stand. A legal nonconforming use shall not be considered a permitted use as defined in 68.3, and 68.3 definition repeats it. A legal nonconforming use is not a permitted use, despite the fact that it may be allowed to continue. So if a residential institution had somehow survived on this property, it would still not be a permitted use, and the zoning letter's determination that the use is permitted as of right, as an accessory use, would still be textually implausible. I had an application before this board a couple of years ago for Rosemary Powers on South Connecticut in Bay Shore. There were 2 single-family residential dwellings on that property, 2. I had to pull up the archives from the Bay Shore Historical Society. I presented to this board proof that my client's use of that property with the dual dwellings on it, I had to prove it to this board. Where's Mr. Bifulco's proof? Where has he gone before anybody within this town and said, ladies and gentlemen up on the dais, this was my use in 1942, this was my use in 1992, this was my use in 2022. I'll do one better. This was my use in 2025. 1 year.
No, I don't think the application is seeking a non-conforming use, though. You're
Is it not?
saying, is that in the, that's not before us. I disagree with you. You've convinced me that it's been abandoned. That the use has
You
been
concede the
abandoned.
point, I'm good.
So, yeah, no, but that's not what they're applying under.
I know. That's
Then
not
why are we spending all this time on non-conforming use?
Well, what I'm trying to, listen, this may be the only, Mr. Wexler, case in point, because Mr. Bifulco has chosen this roadway, he's followed these signs to this board, only through us. He's at the planning board. This may be the only opportunity, the only public hearing that myself, on behalf of the applicants, on behalf of a lot of people in this room, get to present our arguments. You might be the only body that hears us. So am I to shy away from an argument that I presume, if I was Mr. Bifulco, I'd be making this argument. He may not, excuse me, he may not have made it before, but I can assure you he'll make it soon.
Maybe not now that you've
Not
called him
now,
out on it.
now that he's heard us say that it's been abandoned.
Well, that's because you conceded the point. Thank you very much.
I'm not quite sure what your point is.
You conceded that it's been abandoned.
It's not an issue.
Can we move on to
Okay.
the next point?
Yeah,
I'm done with my presentation. I'll be back if need be, but I do need to turn this over to Mr. Campanelli. He has some other better things to say, and we'll be here if you have any questions.
Okay. Good evening, Mr. Chairman, members of the board. My name is Andrew Campanelli. I'm an attorney. I represent Mr. and Mrs. Gregory Collins, who are homeowners who own the closest property to the property which is the subject of this application. I'd like to start by addressing the questions raised by Mr. Wexler, which of course were directly on point. You hit the nail on the head, although the head is a little bit smaller than it should be. So I agree with you that the issue before the board, and it's one that you're squarely qualified to conduct, is the analysis into whether or not the proposed additional uses proposed by this specific applicant would constitute an accessory use to a principal use of a parochial school, even though this applicant has not claimed that that is the principal use to which they want to put the property. And the chairman actually pointed out the standard and the criteria, which is an accessory use can be recognized by this board as an accessory use to a principal use if and only if it is customary, incidental, and subordinate to the principal use. And in this case, it doesn't meet any of those 3 criteria for several reasons. But let me start with the first one, customary. Mr. Wexler, you've referenced a number of boarding schools throughout the Northeast. Well,
And also here in Suffolk County.
that's correct. We're in New York, so let's talk about
So
New
is
York.
Suffolk County.
Suffolk County. The Suffolk County Boarding School out east has 200 boarding students. It's the only one out here, okay? Let's talk about the law of the state of New York, because that's what governs this board. Is the use as a parochial school, is it customary for them to have boarding schools customary to that use? And the answer is no. How do we know that? As of today, there are 157 parochial schools open in the state of New York. 97% of them do not have boarding facilities. Only 3% do. That means it's not customary. Having a boarding facility is the exception, not the rule. Just to make sure you know what I'm talking about, earlier today I submitted a small brief, 9 pages, to all of you, and exhibits in support. One of the exhibits I submitted is an actual list of the current parochial schools licensed and currently operating in the state of New York. There are a total of 157 of them.
Which exhibit is that?
It is exhibit number, exhibit letter, excuse me one second. It is exhibit, I apologize, H.
Okay, thank you.
You'll
Please
see a
proceed.
list of 157 parochial schools. 152 of them do not have boarding facilities. 5 do. That's 3%. That is not customary. It's not the rule, it's the exception. Now,
Let me ask you, you were talking, we can narrow this to maybe 6 miles from here. You're familiar with the Harrow School? Harrow?
is it on the list?
I don't know what's on your list, but I know it exists in Oakland.
Well, I put a list for all of them in the state of New York, so it
What
should
did
be
you
on the
say?
list.
So we have it, and then I can give you the information and you can address it.
Okay.
The Harrow International School, 500 Montauk Highway, Oakdale. It's a secular charter school. It has been permitted to operate by the town, and as part of the planning board's approval for the Harrow, the town imposed operational limitations, including a maximum enrollment of 435 students and a minimum of 348 student beds, consistent with the approved phasing plan. So
Is that a parochial school, which would fall within the definition of the?
it is a secular school.
No
but-
speaking out, please.
No, I'm speaking with Mr. Campanelli.
Thank
But you're not asking us now to start imposing certain regulations on religious institutions. That gets
Religion?
us into a first.
Okay,
Hang
hold
on.
on. Go ahead.
Hang on.
Please be quiet.
You want to just take a break? I don't know.
Give them one more try.
If I
So
may.
you're not asking us to distinguish and treat a parochial or religious school different than a secular school. That takes us into First Amendment land, doesn't it?
Let me make one thing perfectly clear. This application has absolutely nothing to do with religion.
Well, you
Nothing.
just asked me to distinguish between a secular and a parochial school, and
No.
I'm just trying to establish for the record, I don't think you were going there, but you're not asking us to recognize or not recognize a religious institution, Mr. Campanelli. That brings us into a First Amendment constitutional area that we ought not to go. And you know the Constitution.
I've been handling federal civil rights
I'm not
cases for
asking you.
33 years.
I'm not asking you that. You and I have litigated many cases.
Yes, we have.
You beat me a couple times.
I did.
So, be that as it may, you're not distinguishing between parochial.
I'm going by the definition contained in the Town of Islip
The town
ordinance.
code permits a parochial school.
That's correct. I'm only talking about parochial schools because that's the definition and the permitted use, not set by me, but set by the Town of Islip.
And it says, it's 68-45.
Correct.
Hang on. A permitted use is a parochial school.
And by definition, what is a parochial school?
All
All I'm saying is...
It's something that's non-secular.
Okay, well...
Why,
all I
do you
can
have a different definition?
According to the state of New York, I don't make the rules here.
No, I know
didn't
that,
draft
but-
the ordinance. Your ordinance says a parochial school is a permitted use in a AAA district. Got it. The state of New York recognizes parochial schools. There are, as of today, 157 parochial schools recognized by the state of New York. I'm not defining what they are. I have nothing to do with it. All I'm telling you is, of the 157 parochial schools recognized by the state of New York, 97% of them don't have boarding facilities, and thus, boarding facilities are not customary to the use of property as a parochial school. You don't have to have boarding to have a parochial school. 90% of the schools don't.
Let's go back to the Harrow School for a minute.
Yes.
Let's put aside the parochial school issue.
Yes.
Oh, I apologize. The Harrow School. A moment ago, maybe I misheard you. You can clarify. You mentioned that the planning board approved the Harrow School to have dorming facilities.
No, I didn't mention anything.
Did somebody just say about the planning board?
Him.
Okay, so, okay. So did the Harrow School get a planning board approval?
I have no idea. I've never heard of that case before today. Mr. Wexler would know.
I believe it went before the planning board.
I know. So it went before the planning board. So it was not an as-of-right accessory use, correct?
That would sound right.
The planning board did not weigh in on whether or not boarding is accessory to the use as a school. They did not weigh in on it.
Okay. So,
But what did the planning board weigh in on?
Site plan, I believe.
Oh, the site plan.
Okay, no special permit?
If I can defer to Nick here.
Okay, I can answer that one.
Hello. Who's causing the reverb? Okay. That's you, not me. Okay. So let's.
Hang on
I
one
think
second.
Nick
I
was going
just
to-
want to answer his question there. As far as the Harrow Institute is concerned, it went for a change of zone to put on a historic overlay district. There was also some restrictive covenants on the property that limited the uses that were from a previous application. As far as it being used as a boarding school, which as far as I understand it is now, that was not addressed by the planning board.
What's the zoning district that the Harrow School is in now?
It's AAA with a historic overlay district because like the Bourne Mansion is there and stuff like that.
Okay, that's all.
So again, we know every zoning case stands or falls on its own merit. So what type of factual considerations is this board required to consider under New York State law in determining whether or not a proposed use is in fact an accessory use? And New York State law governs, and you are the ultimate arbiters. Zoning boards look at the individual facts of each specific case. What are the factors? Well, by way of example, one of the things they look at is proportional use. If there is a building, and it is claimed that there's going to be two uses in the building, one is the principal use, and one is the accessory use, boards invariably, and courts recognize this is a proper measure, what percentage of the building is being used for the principal use versus the alleged accessory use? If the accessory use occupies more space than the alleged principal use, that weighs in favor of finding that it's not an accessory use. Let's look at this case. There's
Yeah,
three
but
floors.
that's just one of many tests.
I'm trying to adjust them one at a time.
All right.
Okay? First one, 3 floors and a roof. Now, I don't know if any of you have seen the video. There are 2 videos that have been published by this applicant, not me, them. They're alleging that they want to use a boarding school to house 200 students, not 124, 200. It's on 2 separate videos. They published that to the world, and they're raising money using that representation. They told the town they're going to house 124. They're telling the world they're going to house 200. They claim they are going to use the top of the building, 8,000 square feet, as an 8,000 square foot terrace to hold social functions. They're going to have a daycare and kindergarten. They're going to have full weekend activities and weddings. So let's think about this. First of all, just with regard to the residential boarding use, 70% of the building is going to be dedicated, this is as it's currently laid out, 70% is going to be dedicated to use for boarding facilities and 30% towards the parochial school use. So that factor weighs heavily in favor of finding the boarding school use is not subordinate to the principal use. But it gets worse, and here's why. Right now, there are 24 bedrooms. On the New York State Fire Code, they can't put more than 5 children in each of those bedrooms. If they want to house 200 students, that's an average of 8.3 students per bedroom. That is unlawful. It violates the Fire Code. They would have to add 24 additional bedrooms to house a total of 200 students to comply with the New York State Fire Code. So right now, it would be 70% dormitory, 30% parochial school, and the number's going to be even worse if they proceed as is planned. What else do they look at? Revenues. Revenues generated. If there are 2 uses on the property that generate revenue, which generates more? What do you think the boarding school is going to generate? Let's look at the comparable rates. I'm glad Mr. Wexler brought up Stony Brook.
Do you have any case law that supports that?
I do.
Is that submitted to us?
It is. Everything I'm stating is cited by case law. It's in the memo, and I'm not citing it
That
just
re-
for time. There's a lot of people who want to speak.
That revenue controls?
Revenue is one of the factors that's considered. You must look at the totality of the circumstances, each of the factors which dictate to you whether the accessory use is really accessory or not. If the accessory use in size, scope, intensity dwarfs the alleged principal use, it cannot be an accessory use as a matter of law, period, end of story. So what about revenues? They're going to raise money. What type of money are they going to raise? Well, I'm glad you pulled up Stony Brook. Stony Brook has 200 students, which is likely why they chose 200 as the target number for their boarding school. The revenue derived from the boarding of the students at Stony Brook is $70,300 to $70,600 per student. At 200 students, the boarding school is going to generate $14.3 million a year, and there's nothing in the record to show that the parochial school is going to generate anything near that. The money generated by the boarding school is going to dwarf the income from the alleged parochial school. Second factor weighs in...
At the Stony Brook School, you're saying that the dorm section dwarfs the educational section?
The tuition with boarding at the Stony Brook School right now for in-country students is $70,300. For out-of-country students, it's $70,600 times 200 students is $14,360,000 per year.
And what is the educational component?
They don't break it down.
They do, actually.
Oh, okay,
No,
okay.
Based on inference, the tuition for the day student,
Right.
the difference between.
That's true. That's true.
That's what the board.
And what
That's
is
true.
that number?
I don't know. If you allow me to, if you leave the record open for 10 days, I'll provide that data to you.
No, not for that.
But I'm just trying to, so,
Okay.
I'm just, under your analysis, Stony Brook School shouldn't have a dorm or should have I'm just trying to figure out your analysis.
Okay.
You brought it up.
Once
Hang on,
again-
Hang on.
Go ahead.
You said vociferously, $14 million. I think you said it 3 times, so we got it, that's good.
Yep.
We don't know what the educational component is, but as our member, Mr. Nicolia, said we could figure it out.
Okay.
So I'm trying to find out, is that good or bad? Is that you're saying, does that support your application?
Okay.
Is that good or bad?
As you know, every zoning application
I
stands...
know, but you brought it up.
I'm trying to answer your question.
You
Every
keep
zoning...
saying, as I know. I don't know, that's why I'm asking you.
I'm trying to explain, as you know, every zoning application stands or falls on its own merits. They're different. Here's why. For example, each institution wants to house 200 students, right? Okay, great. Stony Brook is 55 acres that houses 200 students. This facility is going to be 13 acres that holds 200 students, not including the 24 on-site staff and employees and the 10 visitors.
Also, they're in a different town.
That's right.
different code.
That's right.
We don't know if that's boarding facilities and accessory use, because honestly, boarding facility doesn't sound like an accessory use.
That's
It's
correct.
primary use.
Absolutely. Everything about this proposed application leans towards the boarding school and other activities, an 8,000-square-foot social event center on the roof of the building. Everything else points to a commercial use of this facility, which totally dwarfs the alleged parochial use of the school. You don't need to have weddings to have a school. You don't need to have a kindergarten daycare. You don't need 7-day-a-week programs. They're advertising 7 days a week, every Saturday and every Sunday, there's going to be programs there. The intensity of the use is so much greater than what is accustomed to being used for a simple parochial school, reflects the indisputable fact that the alleged accessory use...
Can I ask you a question?
Yes.
Again, I just want to, as I'm reviewing our notes.
Yes.
and documents, you keep saying that a dormitory is not a customary use of a religious high school. You keep saying...
I didn't say that. I said a boarding facility is not a customary use to a parochial school, as evidenced by the fact that 97% of them in New York don't have them.
You are familiar with the case, the second department, which you would say is controlling, and that is the Association of Zone A and B homeowners versus the City of Long Beach. You're familiar with that case? If not, again, I'm not
Educate
familiar with
me.
a lot of cases. The second department has held that a dormitory building is customarily incident to a primary religious school use, that such a use variance would not be required for such a use in a residential zoning district that permits schools and places of worship.
That
So, okay,
court
hang on.
made that determination based upon the specific facts and circumstances
I know, but
of
I'm-
that
I'm-
specific case. That's not the case here.
I know, but.
What's the difference?
What's the difference? Hang on. Let me just put this out, and then you can have as much time.
Sure.
You agree that we are bound by the second department? Yes?
Every legal proposition I'm offering to you is supported by a case citation.
I know, but you would agree that the second department controls what
Yes.
we do? Okay, so, I don't know how much interpretation. We need to follow the law. That's what our concern is.
Yes.
And where it says that it is specifically held, a dormitory building is customarily incident to a primary religious school. The appellate division has determined that it is custom or customary and incidental. How do we get around that? Before we get to size,
Okay.
dollar amount,
Okay.
students, those are all interesting arguments, and
Right.
we're making a record for it. But when you say it's not, it is. The law says it is.
There are
unless
also
you-
cases that talk about the scope. Let's say, for argument's
Okay,
sake.
but no, we don't get to the scope
Yes,
yet.
we do.
No, we don't.
Because boarding facilities,
right,
some
we'll get to the
uses
scope.
under limited use can be accepted as an accessory use depending upon size.
Okay, so let me
So
just
let-
ask
what
you
if the boarding faci-
hypothetically,
Go ahead.
hypothetically, if they reduced it from, I think there are 124 students.
Right.
If they you're talking about size, not that the appellate division does. They're simply making the proposition. That's like saying there are 50 states and they are part of the United States. Oh, but Alaska's large and Maine is small. Well, that's not the proposition. So getting beyond that, if the school said, okay, we'll limit it to 60 students, then it's okay?
That is a determination for you to make. Make it
I
clear.
know, but I'm asking you.
I'm telling you that there is an additional case that says, even if a use is customary, it depends upon the size and scope. So that if, for argument's sake, you determine that given the size of the parochial school, 40 students dormitory is customary. What about if they say, well, we want to house 10,000 students? The second department is very clear. Some uses are permitted as accessory uses when they're of limited scope. In other cases, when they exceed the limited scope, they're no longer accessory uses. The principal case from the second department has to do with an antenna. Young man had a ham radio. He had a 10-foot antenna on his roof. That's an accessory use. It was fine. He took it down, he put up a 50-foot antenna. The second department said, oh, listen, the use of an antenna is an accessory use to a home, but not when it goes 50 feet tall. Same analysis for what you're saying. Housing
So if
200
they made it-
students
if they
is not a
made it-
custom. I'm sorry.
We don't need to yell. If they
I want to make
made
sure
it-
they can hear me. I'm not
That's
trying to be
okay.
rude.
I'm concerned. Andrew, everybody can hear you, okay?
I have a big mouth, yes.
No. My question is, first we have determined that it is an accessory use. The next issue, the next issue is we need to look at the scope and size.
No.
We don't
You have
look
to
at the scope
determine the
and size.
scope and size in determining whether or not it's an accessory use. You're putting the cart before the horse. The law is crystal clear
So
in the second department.
if we said 60 students, then is it okay?
It's the totality of the
I'm
circumstances.
just asking, is 60 okay?
It depends upon the facts of the case.
You don't wanna
What
get pinned
percentage?
down.
What
You don't wanna get
percentage of
pinned
the
down.
building would 60 student dormitories occupy? Is it 10%? Is it 95%? You can't view them in a vacuum. That's impossible.
But we don't have those numbers in our code.
Yes, you
And it
don't
goes-
need them in the, okay.
But you're going back to, we're fighting with what the second department has said, that
No,
we
we're-
can't engraft numbers. That's their language.
Absolutely not. The
That's
second
not their
department
language?
has invariably held, you are the ultimate interpreters of the zoning code. And you are the ultimate determinants as to whether or not a proposed use is an accessory use or not under the totality of the facts. You have to look at all aspects of the proposed use: the intensity, the size, the proportional scale, the revenue, the traffic generation. It even says you have to consider the potential adverse impacts on adjacent neighbors when the use is proposed inside a residential district. I cited the case, it's in my brief. So you can't look at any one factor in isolation. Look at what they're proposing. Having 200 students and an 8,000-foot platform to have social events and weddings and a kindergarten daycare, is all of that incidental to a parochial school in totality, and it's not.
If we said they can have weddings, would that
In isolation, not necessarily. What if it's a wedding of 3 people? You have to be realistic. Every zoning case stands or falls on its own merits, and this case is
But
no
it-
different.
It's also a religious institution.
That doesn't matter.
Hang on, just allow me to finish. If it is a religious institution, and I believe they're going to have a mosque there, is there a church or a synagogue that doesn't conduct weddings? And what is it, baptisms? Is there one that, you can go across the street, there's 3?
That's right.
Of course they do.
Of course. Okay, okay.
So are
How-
you saying that they couldn't conduct a wedding like right across the street?
How large of a
Maybe
wedding, Mr. Wexler?
I'm just saying, no.
How
Don't
large? Can they have
bootstrap it.
10,000 guests?
Could they conduct a wedding?
Theoretically, yes, depending upon the size, scope, and intensity.
I agree, but that's set by fire code, that's set
No,
by
no, no,
building
it's
code.
not. When
Oh,
it
it's
comes
not?
to
Okay.
determining whether or not the proposed other use is an accessory use to the principal use, or if it becomes the dominant use, that is a factual determination that this board is required to make, and you have the power to make it.
So hang on one second, so we're going to tell, again, a religious institution, like us telling it, we're going to tell a religious institution, like we're going to tell St. Mary's, that you can't conduct a wedding? And we want to know how many people? Could we do that, Mr. Campanelli?
Once again,
Could we
Mr.
tell-
Wexler.
Hang on, don't tell me it's individual. Could we tell St. Mary's right in East Islip, or one of the churches across the street, that they can't conduct a wedding unless the zoning board, they tell us how many guests?
No, that's not the inquiry that you're looking at. The inquiry you're looking at is whether or not the proposed use is an accessory use to the principal use.
I just want to bring one thing up about the Long Beach case.
Fine, fine. But yeah, I just want to point out for the Long Beach case that, yes, it was an accessory use because the 2002 case that determined that building had been used as a dormitory since the 1970s. So it's been an accessory use for that building for a long time. That's why it was an accessory use.
Mr. Wexler?
Hang on one second. Make it, because we're not making. Okay, now it's on. Now we take a
We're gonna take a 5-minute recess to calm this crowd
I
down.
can't hear you, I'm sorry.
We're gonna take a 5-minute recess to calm the crowd down.
Thank you, Mr. Chairman, thank you.
Ladies and gentlemen, that's not helpful. I say it's not helpful.
I have that case. He called it the wrong thing. You should have had it too. And I don't know if we need to address it any further because generally what happened was they went for a change of zone on this. It is a AAA zone. They went for a change of zone because it was a planned preservation.
This is the Long Beach case?
No, this is the one they were talking about in Oakdale.
Oh.
I don't know if you want to bring it back up.
Nah, it's
You
not
don't really
necessary.
have to.
No. Andy Campanelli.
You're doing great.
Thank you.
The occupancy issue he's trying to bring up, what you can't fit, 10 pounds in a 2-pound bag of shit. If the occupancy says, there's 100 people, that's fucking it.
Yeah.
He's trying to throw this all
No,
off.
Oh, I know.
He's doing his job. Listen,
I can attest to that it was never a dormitory. It was always a retirement home for free. It's still 1973.
I got it. You can get up and say that.
The Darrow School was the Sal Military Academy. I went there. It started in 1933, and it was always a boarding school. And it's
How many acres
It's
is
on
it?
180 to
Right.
200 acres.
You should get up and say that.
Okay. Well, if you want me to, I will.
Yeah.
Because that's totally irrelevant to what
It
we're
was a retirement home. It was never a
I get it.
dormitory.
I get it.
You're a celebrity.
I stayed there during the hurricane.
But they do have celebrations coming, so I don't want to go down that road.
So if you want me to say that.
Yeah.
So I graduated in 1974.
Yeah, definitely. When you get a chance, get up and say.
Good job, by the way.
You guys are doing a great job.
Thank you. Yeah, I got it. I'm sorry, we need to just move away from this.
You gonna speak? Oh, there he is.
Mr. Cabanelli.
Yes.
This thing has to go. It's blocking the view of the board.
Okay.
It's very bright. It's
Okay.
causing eye strain.
So, can I?
told them they could come at 5:30 to select a location.
Okay.
And I would be here, and at
Okay.
5 o'clock, I got a call that they're here.
Okay, hold on one second. Are they going to let me play a 30-second video? Because then I can take it down right afterwards.
No, bring it down now. I can't see.
Okay.
It's disruptive to the board.
Okay.
And it's bright light and
Okay.
marble.
Okay. Okay.
They came a half an hour before they were supposed to.
Okay.
We don't need.
Take the screen down.
No, yeah, we got it.
Why can't they won't let us show it?
She says it's blinding her, and it's blocking her view. Take it down. I don't want to lose her. Please, take it down.
I know, trust me.
We're doing our job. I can't tell them that. They won't listen to me, but I would if they all left, but I want to do it while they're here. I know. I'm good. I'm good. Take them down. Don't worry about it. Take them down. I'm going to give them video. Take them down.
You're doing good. You're doing good.
Thank you.
Keep up the fight.
Thank you.
Good luck, gentlemen. We're taking off.
You leaving us?
Yeah.
I better get
My
it.
mother's in town, remember?
No problem.
Testing, testing. Testing. I don't know. Yeah, when I'm close to it, okay.
Good. Mr. Campanelli?
Yes,
When you're ready.
just some quick citations to answer questions by Mr. Wexler. One, with regard to the revenue generated by the property, there's a case called AIM Rent-A-Car v. Zoning Board of Appeals of the Village of Montebello, 156 Appellate Division 2nd, 323, 1989, which held that when the accessory use of the property generates more revenue than the principal use, the accessory use should not properly be considered as an accessory use. Did I say that right? The one that makes more money is the principal use.
Yeah,
Let's do it
we
that
got
way.
you, we got you. What
All
was
right.
the year of that?
The year of that case is 1989.
Okay, thank you. Was that third department or second?
Well, it's Village of Montevello, so that might have been third department.
Yeah, okay, thank you.
With regard to the fact-based inquiry, just New York State law is very clear. Second Department makes it very clear. Whether proposed use is subordinate to the principal use of property is a fact-based inquiry, which requires an analysis of the nature and character of the land in question and requires consideration of the overall character of the particular surrounding area, especially when it's a residential district. That's New York Botanical Garden versus Board of Standards Appeals of the City of New York, 91 New York Sub 2nd, 413, 2002. For additional uses to be recognized as subordinate to the principal use, any alleged subordinate use must be proportionally small and less extensive than the principal use it purportedly serves, and it must not rise to the level of being dominant or equal to the use, a dominant or equal use of the property. The most fundamental judicial gloss on subordinate use is that the accessory use must not be the dominant use of the property. And that's People versus Needleman, 305, New York Sub 2nd, 708, 1969. It's still good law. It's been upheld every time, even by the Court of Appeals. So these are the basic factors. You are the ultimate finder of fact. And by the way, your decisions are rarely overturned. It's a very high standard. You have to look at the
Why is that?
Because, unfortunately, New York State Supreme Court judges do not want to become zoning boards of appeals. They hate it. But you have a job to do. Look, the bottom line is this. You adopted a zoning ordinance which created zoning districts, and it's done for a purpose. This town, like every other town in the state of New York, recognizes some uses of property are incompatible with adjacent uses. Use for property as a car wash is a perfectly legitimate use of property, but you don't put it in the middle of a residential street. Why? Because everyone would recognize that the use of property for a car wash would be inconsistent with the use of properties adjacent to it as homes. Can any one of you think of a case where you would approve a use of a property where you have a 3-story building, 8,000 square feet on the top, and you would allow the owner of that property to have social events so that hundreds of people would stand on top of that roof and have parties and play music while they peer down over the adjacent neighbors who would be precluded from the opportunity of just sitting in their backyard or after a day of work and just enjoying a glass of wine and not have to watch 800 people peering down over them? You'd never approve that. There is no way that this board can find.
No grandstanding.
I'm sorry.
No grandstanding.
I didn't try to do that. I'm sorry. There's no way that you could plausibly find that the intensity, the scope, and the revenues generated by these uses, which is not just a boarding school.
Revenues. Do you have the revenues that this school will generate, the dorm versus the educational component?
As I said, I can get that breakdown for
I know,
you.
but no, I get that, but you're saying it is, you're saying it as if it is a fact, and we don't even know what it is. So at this juncture, we're left to speculate.
Well, we're not speculating what the gross revenue is. We know if it's comparable to what Stony Brook is
But we
charging.
don't know. Do you know what their rates are going to be or what the fees are going to be?
Suffice it to say, there's evidence that there's reason to believe that the money to be generated by the boarding use of the property will greatly dwarf the money generated from donations from the
on what?
parochial school, based upon the use of comparable institutions and the rates of tuition being charged by the comparable institutions, including here on Long Island. Any other questions so far? Is anybody still awake?
No more grandstanding.
I'm not grandstanding, thank you. So look, we didn't get permission to play the videos. I think they're dramatic. I am including as an exhibit to my presentation a flash drive with both of the videos. I implore each of you, in fulfilling your duties as a member of the ZBA, watch these videos. Watch the actual use that's intended for this property. And you determine, as you've been trained to do, whether this use that they're showing you is an accessory use which is subordinate to the use of this property as a parochial school. And I thank you for your time.
Thank you.
Before you, Mr. Campanelli, I had some questions for you.
Yes.
We were going through some issues regarding what is incidental. And I want to ask, because I've done some research on this, and I've researched a lot of cases speaking to what is incidental. And the courts lay out for us to follow a series of about 6 or 7 elements and questions. And again, I'll read them to you, and then, just so we have a record, and then I'd like to hear your opinion and how you opine on that. The first test, and this is specifically with parochial schools and dorm and the educational component. And first of all, the things that we have to, because we have to make a determination, as you and Mr. Bertolino have told us, and we all agree with you, is that first is the dormitory only for enrolled students? i.e., it's not rentals for people unrelated. That's like the first thing. You have to be an enrolled student. And I don't know, we could make that as part of a condition, but I imagine, as I understand, this is going to be K through 8. Is that your understanding, the enrollment?
You want to answer that?
Mr. Wexler, I don't know whether it's going to be K through 8, but I can tell you on the video, the applicant, or the underlying institution behind the applicant, clearly sets forth that there are 14 guest rooms.
Okay.
So is this going to be used primarily for boarding of students exclusively? Not according to the
Well-
video, which you should watch.
Well, okay, I don't think,
Please, let us speak to the attorneys.
I forgot that. The video does say that there are guest rooms, so they have guest accommodations for non-students.
well, if we made it a condition that it would only be for enrolled students.
That's the golden ticket. You can't make it a condition, and here's why.
Oh, I'm just
If-
saying,
if-
I thought with the zoning board, I thought we could.
No. There's no
But
zoning
once again-
application
but
before you.
Once again, you want us to speculate what they're going to do or not. We don't know. You don't know, I don't know.
Okay,
Okay.
two things.
Listen,
Come on. Two things, Mr. Wexler. First, I'm not speculating. I'm telling you what they are saying they're going to do. This didn't come out of my mouth, it came out of theirs. Number one. Number two,
They said they're going to have non-students living in
guest
the
rooms.
dorms?
They're going to have guest accommodations, 14 rooms for a guest. What's a guest? It's not a student.
Well, yeah, these are questions we will ask them.
Okay.
But I have a feeling, since I kind of know boarding schools, that the guests are often parents that stay over.
The other
So
issue.
you mean the parents couldn't stay over if they were visiting?
You asked me. You asked me if the dorms.
You know, folks, this is, what we have done in the past is we just close the hearing. It's just not polite to yell out at us. I don't know why. I'm not saying, I think it's only a few people, but I don't know why you're doing it. Okay.
Don't, guys, don't. You asked if the dorms would be limited to students, and according to the applicant, the answer is no.
Okay, all right. The next question, does the, and this is what the courts have given us, does the right to live in the dorm end with the enrollment?
No, not if they have guest accommodations. The answer is no.
Okay, so you think the parents would stay, and we're going to have these questions for the applicant.
Who's a guest? It could be a visiting alumni. It could be anybody.
I know, but if I'm saying we don't know, you're speculating, I'm speculating. We will find out from them.
Okay.
But would you say that a parent visiting their kid at boarding school would not be able to stay? That would make them a guest?
I don't
I'm
know.
just asking.
I don't know the answer.
All right, well, I don't either.
But here's the other thing. You mentioned you could
Hang on,
impose.
let me just finish.
Okay.
And another test that the courts lay out for us is the school owns, controls the facility. I think that's going to be here. They own and will control,
Well,
right?
the parent entity would.
Well, that's the school.
Okay, go ahead.
Rules set forth by the students and residents. The school sets forth, isn't that the way most parochial and dorm, or you don't know?
What is the question?
The question is that the courts tell us that will the school set forth the conditions which the students live in the dorms?
Presumably.
Okay, I'm going through the questions. No rooms will be rented to the general public or people having no incidental relationship to the school.
We have
It's
no
not
way-
going to be rented to anybody who just wants to live there. Fair enough? Is that
We
your
don't know that
understanding?
because they're going to have private functions, they're going to have weddings and other
Okay.
functions,
Okay.
for-profit functions, and there's nothing to stop them from renting rooms to those
Okay.
people.
And just
If a
one
couple
more.
comes here and gets married, what's to stop them from saying, and by the way, we're going to rent you
And
the bridal suite,
Does
which is on the third floor?
residents support the educational program? Are they interrelated? Is there a nexus?
Theoretically, yes.
Okay. And the occupancy is tied directly to the school enrollment.
Not necessarily.
Who would be there who wouldn't be a student?
Guests, people.
Well, we
wor-
keep, okay, all right. Okay, thank you.
Okay. You raised one other issue, and you said we could place a limit on that. You touched on a golden issue, and here's what it is.
Everybody keeps giving me compliments. I
What
don't
should
know why.
happen here is that this board, I respectfully submit, should recognize the proposed use as not an accessory use. It's an additional use. In fact, if not equal, it's superior use. And what should happen is, since a boarding school as a dominant use is not a permitted use in this zoning district, this AAA residential zoning district, they should be required to apply for a use variance before you. If and only if they did that, you would then have the power to grant or deny this application and to impose whatever conditions you deemed appropriate to protect against the potential adverse impacts that the neighbors in the community would suffer. You could put a limit on the number of students they could have. You could say you can't have parties on the roof with 1,000 people beyond 11 o'clock at night. And the only way that's going to happen is if you determine that this use, which is clearly not incidental based upon the size, intensity, scope, revenue, is not an accessory use. Thus, if they want to have all of this stuff, not just a parochial school, but weddings and a kindergarten and all these other things, they'd have to apply for a use variance. And then you have say. You get to enforce the code for the intended purpose. Your code states you codified the legislative intent. And if you allow this to go through, this project will inflict upon the surrounding community and the neighbors the precise types of adverse impacts that the town of Islip adopted a zoning ordinance to prevent in the first place. Thank you.
Thank you. Mr. Bifulco? Mr. Bifulco, would you like to speak now? Is he here? Oh, okay.
Good evening, Mr. Chairman, members of the board, members of the community. On behalf of the United American Muslim Association, my name is Samuel L. Bifulco, partner with San Ward Braff Castigliano PLLC, with offices located at 1300 Veterans Memorial Highway, Suite 100, Hauppauge, New York, 11788. Joining me this evening are members of the United American Muslim Association, owners of the subject premises. Before I begin, please allow me to thank the board for their service to the town, the community for coming out to talk about this important topic. On behalf of my client, owner of the property in question, we appear in opposition to the applicant's appeal to the town and/or their request for an interpretation as to whether the boarding constitutes a permitted accessory use to a parochial school. My client acquired the subject premises on June 17th, 2026, from the Montfort Missionaries, a Roman Catholic religious congregation of priests and brothers. The board may know the site as the Montfort Spiritual Center, which was founded in approximately 1926. Until on or around 1972, the Montfort Missionaries operated a Catholic seminary and boarding school for teenage boys on the site. Since then, the property has served as the headquarters for the Montfort Missionaries, used as not only a headquarters and a retreat house, but also a home for aging priests and other members of the Montfort community. Included in your exhibits package as Exhibit B are several photographs showing the way in which the building has been used historically, depicting the existing bedrooms. The subject premises, located in the AAA residential zoning district, consists of approximately 14 acres and is improved with several structures. A building division certificate has been submitted for your review as Exhibit C. The certificate identifies the existing 3-story structure located on the property, which is certificated for a seminary building, which is generally understood to mean a specialized school for educating and housing clergy, priests, ministers, and other religious figures and students, and serves as both an academic school and residence hall. A little bit about my client for the board's consideration, as well as the proposal, to make sure that it is clear what is being proposed before the town at this time. The United American Muslim Association is a nonprofit organization established in 1980 with a mission to foster Islamic education, moral development. There are a number of pieces of information that I'm going to share with you. Well, there's much here that I'd like to get into the record, and so I
Listen, ladies and gentlemen, there'll be no clapping, no booing. Please let him make his presentation.
The proposed use, known as the Bayshore Academy, contemplates a parochial school with boarding facilities providing religious and secular education to 120 male students. Pursuant to Section 6845B of the Code, and as further confirmed by the zoning determination at issue, submitted this evening as Exhibit D, the proposed use, a parochial school with ancillary boarding facilities, is a permitted use within the AAA residence zoning district. Students will reside on campus and will participate in a structured educational environment that includes secular academic instruction, religious studies, and recreational programming. Approximately 20 administrative, faculty, and staff members are expected to reside on campus in
What
support of the
grades
operation.
will the students be?
Sorry, what was that, sir?
What grades will they be?
Grades 7 through 12.
Oh, 7 through 12?
Yes, sir.
Okay.
In addition, approximately 10 teachers are expected to commute to and from the campus daily. Other than the approximately 10 teachers expected to commute to and from the campus daily, we expect minimal third-party vendor traffic to and from the site. As mentioned, the student will consist of middle and high school-age student males. Secular instruction is anticipated to generally occur between 9 and 3, followed by religious studies and other organized activities. The primary 3-story building contains approximately 68,500 square feet, consisting of 22,800 square feet on the first floor, approximately 30,000 square feet on the second floor, and approximately 15,000 square feet on the third floor. I provided conceptual floor plans prepared by Ralph Architecture for your review as Exhibit F. Of the approximately 68,000 square foot building, it's important to note that only approximately 22,000, or 1/3 of the building, is designated for boarding. So if we were to go by the applicant's own measures, that shows that the educational facilities are a primary purpose of the building, while sleeping quarters is incidental. As depicted on those floor plans, you'll note that only minor modifications are contemplated at the site. Additional details regarding the intended use and occupancy of the various portions of the building is set forth in the letter of use dated January 5th, 2026, provided as Exhibit G. On the site plan provided as Exhibit H, the board will note that the site has not yet been fully engineered. The conceptual plan was prepared for the limited purposes of depicting existing site conditions and illustrating a potential parking layout. Now that I've described the proposal briefly for the board's consideration, I want to identify what this proposal is not. The application before the board is not for an assembly hall. It is not for a wedding venue. It is not.
Will they be holding weddings there?
At this time, having spoken to my client.
Ladies and gentlemen, please.
I don't remember hearing this guffaws when the other attorneys were being heard.
Mr. Bufoka, please continue.
Straightforward.
There was a pause there. So.
The application before the board is for 120 students.
No. Let's go back to the wedding part.
Yeah,
No.
I asked you a straightforward.
That's,
No, you don't
Hang on,
want to go
just
back to that?
Wait,
I-
one second.
no, I didn't
Just
say that.
Wait,
Oh.
wait,
I
just
s-
wait 1 second.
sure.
Just want to get quiet, because
Sure.
people say they can't hear. As Mr. Nicolia said, let's go back to that question.
Sure.
Tell us about the weddings, or not weddings. And are you going to commit to no weddings? Just tell us what the plan is.
Absolutely, and that's what I was describing. To answer your question, no weddings will take place at the facility. I'm going to speak about some things that will not happen there.
When did that happen? Because I've been hearing stories about a video that was showing.
I'm going to address that,
Okay.
sir, if you may.
So
Again,
we can all write down no weddings are going to be at the facility?
yes, sir.
And no catering events?
Yes, sir, which I'm also going to highlight.
Thank you.
Again, I just want to reiterate so that I'm comprehensive.
Please.
The proposal before the town is not for an assembly hall, it's not for a wedding venue, it's not for a public assembly. It is solely for a parochial school with boarding facilities, as previously described. It's not for 200 students. The application before the town is clearly for 120 students. All buildings and amenities on campus, which is clearly articulated in my letter of use, all amenities are strictly for the use and enjoyment of the Bay Shore Academy community, namely students, faculty, staff. I recognize.
What about, hang on.
Sure.
I'm an equal opportunity interrupter, I'm sorry. Was brought up by Mr. Campanelli and Mr. Bertolino several times, and I want to address it. What about the guests? They say that in this video, which we have not seen, there will be accommodations for guests.
I'd like to address the guests and the video. I'll start by.
I don't care about the video. Tell
Sure.
us about the guests.
The guests. There are 23 bedrooms on the third floor, which are earmarked for guest and staff rooms. The overwhelming majority of them are going to be utilized by residing on-campus administration, faculty, and staff, of which we're approximately 20. And yes, there will be several guest rooms which will be specifically used for members of the United American Muslim Association who may be visiting out of town, who are connected to the facility and logistics and operations, and/or parents of students who may be on campus. But I do just want to mention at this time, none of the bedrooms will be utilized for rental purposes. None of the bedrooms will be for individuals other than those connected with the academy.
Pay for that use?
No, sir.
You're gonna let anybody who wants to be a guest there stay there?
I mean, that's why I was not going to turn it on. I don't know what it is. Is it your stuff?
No. Those who are considered guests within the context of this proposal are directly affiliated with ownership. No, they have to be affiliated with ownership and the logistics and operations. I would pose that question to the board. I mean, sure. Sure, I understand. Yep, that's a great question, sir. And I would say that it's short-term for specific purposes. If a parent comes into town and has to stay there for financial purposes, whatever the case may be, while they're picking up their children, that would be a use for a room of that nature. If a individual who works at the Pennsylvania boarding school facility comes into town to help train some of the administrative staff, if and when this were to open up, perhaps they would stay in a room for a short, finite amount of time.
But again, that's gonna be all at the discretion of the people running the place there. Nobody's gonna know, as far as the residents there, who's gonna be staying on a regular basis. It's gonna be completely up to you, under the discretion of the facility. So you, by you, we mean your client.
Sure, of course. I completely understand the board's point, the board's concern.
That's our concern, that's not gonna make the use of that facility just for boarding school. It's gonna open it up to a lot of other problems.
Sure. As I've mentioned, and as I'll say
How
again.
how do we take that? We all understand that at a religious institution that has boarding, the bishop or the Monsignor comes in from the city, of course they have a place for him to stay. That's what happens with churches. What I'm saying is, how do we know? Now, I've seen pictures of the rooms. I wouldn't compare them with high-end Airbnbs out in East End. I mean, they look like even less than a dormitory room that at least I remember from college. But how do we ensure that there will not be people unrelated, as he just left, or actually Mr. Nicolia, it's not going to be the headmaster's brother who's having some difficulties and he wants to hang out there? How are
Sure.
you your client, the sole arbiter? We need to know these.
Sure. This, separate and apart from this hearing, this proposal is undergoing an administrative site plan approval process via Town of Islip. There will need to be an administrative site plan approval granted for this process to proceed. I would suggest, and I can speak on behalf of my client and say that we're very amenable to having certain concerns be memorialized within that administrative site plan approval.
And we do that, the town does that regularly. I mean, they institute rules, regulations, and, okay, that's certainly something that we need to know. What about, now I'm paraphrasing Mr. Campanelli, 8,000 people at a party on the balcony?
An 80,000 square foot terrace.
Oh.
Sure.
Yeah,
So-
roof terrace.
The roof terrace. How do we address that?
Absolutely.
Again, I don't know if many religious institutions have wild parties. I've never seen them in any of the churches. But, be that as it may, what guarantees do we have, other than your clients say so, that that will not happen?
I recognize that certain marketing materials may have suggested other potential uses throughout this process.
I think it's a little bit more than
Sure. Suggested, shown, displayed. I have spoken directly with my clients about those marketing materials. I can affirm that the application materials before the town are accurate, and one of those components, I've spoken about this with certain town officials, the roof will not be utilized in any way, shape, or form other than its current configuration, which is for utilities and other, standard features of a roof. It will not be utilized for social events, and that is something that, in the event we were able to obtain the administrative site plan approval process, we would be happy to memorialize within those contents.
Do you plan on making future applications to make that use for that stuff?
For a rooftop facility, no, sir.
Amongst other things, is there future application plans to do that?
No.
Would you tell us?
I would.
Maybe I missed it, kind of step out for a second, but where did that come from, that was going to be used for that purpose? Well, they didn't make it up, it had to come from somewhere.
Absolutely, and I'm not sure if you heard what I mentioned. No problem. I recognize that there were certain marketing materials that were out there, dating back at least a year or so ago.
They only bought the facility less than 5 months, is that?
Sure, they've been in contract for 8 to 10 months, and so during the course of that process, there was a lot of excitement. I'm sure many people, would have seen that certain marketing materials, there is a dramatic effect, there is a sense of optimism. Those marketing materials were created before I got involved.
So what you're telling us is that your client repudiates that video?
Yes.
And it's okay.
And when did
So
they do
it-
that? Is that now? They're now announcing that?
No, I spoke to my clients about those videos when I first learned of them, probably about 6 to 7 months ago, and they'll tell you I was the first to say, remove the videos, and much of what is in the videos is not going to come to fruition.
Okay, but you're telling us what you're not going to be doing, which is fine. People say things and then repudiate them. I'm following up on Mr. Sullivan's question is, what board do you plan to go before for the writing down of these covenants? What board is out there? What board must you go before? I don't know of another one.
Sure. So I have.
Just to answer this question, just as far as the people who are here present tonight,
understand that's a problem.
Mr. Sullivan, I can absolutely understand.
So what board, what agency, what governing body do you foresee having to go before to be able to put these, and we're writing them all down, we'll have a record in writing?
I do not believe that this application has to go before any board for any discretionary approvals. However.
So when you say, hang on, let me just,
Let him just finish that.
However, I do believe that this proposal needs administrative site plan approval from the town's Department of Planning and Engineering, at which point it is my position that any concerns can be memorialized within that approval.
Okay.
But closed off from the public.
Yes, sir.
Well,
It just strikes me as so odd that you could put 10 beds an acre, basically, with no public hearing, where you can't do that in any other zoning district or any sort of application in the town of Islip. This is basically a rubber stamp on 10 heads an acre. That's a lot. That's significant. You're a zoning attorney. What other town allows you to put 10 heads an acre without having any sort of public hearing approval? That seems to me over the top.
Sure, if I may.
Listen, whoa, no, please, no grandstanding, please.
Sober homes and institutions all require some level of public hearing. I don't understand how this is an accessory use without a public hearing.
I acknowledge your concerns. I have additional remarks that I'd like to discuss. The question before the board is whether boarding is an accessory use to a parochial school. So I'd like.
And that my comment relates directly to that.
I understand. I'd like to hit on some of that information.
I can't imagine how the max density in the town of Islip, I believe, is like 12 units per acre, 12 households per acre. I can't imagine how something coming even close to that can just be an accessory use in the most restrictive zoning district in the town of Islip. That to me, that seems,
Sure.
I don't know, it flies in the face of logic.
So, if I may continue with my presentation. As to the merits of the application before you tonight, the plans examiner's zoning determination is rational and consistent with the town code, especially in light of the accommodation and deference the United American Muslim Association is entitled to under federal and state law. Town Code Section 6845B plainly states that a parochial school is a permitted use in the town's AAA residence zoning district. To be considered a parochial school, the institution must be affiliated with a religious organization and offer a curriculum that includes both religious and secular education. Therefore, this is a parochial school. In addition, pursuant to Town Code Section 6848J, customary accessory uses, structures, and buildings are permitted, provided that such uses are clearly incidental to the principal use.
I'm not disputing the fact
Sure.
that it can be a parochial school at all.
Sure.
It has been a parochial school for over 100 years, or a parochial institution. I get that.
Sure.
What I can't wrap my head around, and it has nothing to do with the tenant or the occupant, is how you can increase the density to 10 beds an acre, roughly, whatever it works out to be, without any sort of public hearing, and calling it an accessory use. There's nowhere else in the town no other facility in the town of Islip, granted the Harrow School now exists, but allows that. It flies in the face of logic to me. I can't wrap my head around it. But
I am going to speak about the Harrow School. I do need to get this commentary into the record. So if I may, I think it may answer some of the questions that you have. I understand. In the zoning determination, the plans examiner correctly concluded that the proposed religious boarding school is a permitted use within the AAA residence zoning district because it qualifies as a parochial school. The plans examiner further concluded that the boarding facilities constituted a permitted accessory use as they are, in fact, incidental and subordinate to the principal use.
The plans examiner, we are the ones who can interpret the code, not the plans examiner. With all due deference to Dan Burgos, he spoke out of school there. It's our job to decide that, not him.
Sure. The conclusion is consistent with both the facts and the town code. The boarding facilities exist solely to support the educational mission of the Bayshore Academy. They have no independent purpose or function apart from the operation of the school. In my view, the analysis is straightforward. Absent the parochial school, there would be no need for the boarding facilities. Because the boarding component is entirely dependent on and serves the principal parochial school, the educational use, it is properly characterized as an accessory use that is incidental and subordinate to the permitted parochial school. Of importance, New York State law mandates accommodation and deference under local zoning laws for religious and educational uses, such as the religious boarding school proposed by my client. New York courts have long held that such religious and educational land uses are clearly in furtherance of the public and general welfare. In addition, the Religious Land Use and Institutionalized Persons Act prohibits the implementation of land use regulations in a manner that imposes substantial burden on the religious exercise of a person or religious institution in absence of a compelling state interest achieved by the least restrictive
Could you
means.
slow down a little bit, please?
Yes. RLUIPA also prohibits the imposition or implementation of any land use
Didn't slow
regulation.
down. She can't get it.
I understand.
I've been in your spot many times, I get it. Just try to speak slower for her.
Thank you. RLUIPA also prohibits the imposition or implementation of any land use regulation in a manner that treats a religious assembly or institution on less than equal terms with a non-religious assembly or institution, discriminates against an assembly on the institution of basis of religion, or totally excludes or unreasonably limits religious assembly or institutions. In New York, municipalities and zoning authorities can't prohibit or exclude religious and educational uses from residential districts and are instead required to make every effort to accommodate those uses. Administering the town code to permit a parochial school in the AAA zoning district and to allow customary incidental boarding as an accessory use is in alignment with not only the text of the town code, but with also federal law and New York State law and protections for religious exercise. Construing a parochial school to categorically exclude any residential boarding component, as the applicant would have this board do, would uniquely burden religious boarding schools, such as the one proposed by my clients.
I'm sorry, the thought came into my head, and it was raised by, I think, Mr. Campanelli. What's the limit? Suppose you said next month, or your client, or next year, we want 200 students, we want 300 students. What sets the limit?
First and foremost, occupancy loads in accordance with New York State building codes. Second, again, I will point to the administrative site plan approval that would have to be rendered by the town of Islip in the event they looked upon this application favorably.
What is the occupancy requirement by the New York State?
We're proposing 120 students. As the structure, I just confirmed this with our architect today, as the structure currently exists in its current configuration, the occupancy load is over 1,300 individuals. Yes.
This building, I doubt it has more than 10% of the FAR on almost 14 acres. You could just keep building and building and building.
In theory, yes. Well, all of these concerns can be adequately addressed by the administrative site plan approval process that the town of Islip has in place for situations such as this. The zoning code clearly states that, yes, while a parochial school is permitted, it's subject to administrative site plan approval, in essence.
Is that a one-time approval?
Yes.
And what, can you define, because I'm not familiar with what is administrative site plan approval. It sounds like administrative discipline where the commanding officer issues it and there's no other, that's it. It's like a captain's mast. What is administrative site plan approval? I don't even know.
Based on my conversations with the town, it is an application that doesn't trigger any discretionary approvals which would require a board appearance, one of which I'm going to highlight in my next excerpt.
There's no public hearing associated with it.
That is correct.
It's like a glorified building permit. You file it, it gets submitted, and
So long as you meet certain land and development standards,
and then gets approved.
because it's permitted.
If you said that we want to have 600 students, could that be denied by the administrative site plan review?
My feeling and understanding is that, yes, they can put conditions on our administrative site plan approval. Our application, both memorialized in my letter of use, memorialized in our conceptual floor plans, conceptual site plan, all outlines 120 students. So in my view, an increase in that student count would require going back to the town for an administrative site plan approval. Everything memorialized in the application materials calls for 120 students.
Okay, just so we're clear, that's what every building proposal will eventually go through is site plan review. It's not something new or old, am I correct? That's the
Yeah,
standard.
sure. Any commercial or, large-scale
every-
project, sure.
Every town in the state of New York has the same provision. You have to go through site plan review.
Most
towns require a public hearing. But Islip doesn't in that regard.
It's dependent upon the size, scope, and relief that's required. If we needed variances similar to an application I'm about to run by you, we would need to go, which, if I may, I'd like to highlight a proposal that was before this very town board in 2025.
We're not the town board.
I understand.
Okay.
In front of the town of Islip Town Board.
Are we
In
supposed
Oakdale.
to be familiar with it? I mean, you're proposing it like we know it, or will we
I'm
know it, or-
going to share with you some insight as to the proposal I'm speaking about. It's been spoken about earlier in the hearing, and I'd like to provide some additional context.
Okay, the relevance is, can you tell us what it is so we have a reference point?
Yes. So in Oakdale, on the former campus of the LaSalle Military
Oh, the Harrow
Academy.
School.
Sorry, the Harrow
Harrow-
International
okay.
School.
Okay, all right.
So we'll speak about the Harrow International School. In Oakdale, on the former campus of the LaSalle Military Academy, the Harrow International School, New York, operates a secular, elite British-style day and boarding school. The underlying zoning district on this property is AAA residential zoning. Last year, on July 12th, 2025, of which I provided to you as Exhibit J, the town board granted an application with respect to this property. They heard this application for this secular boarding school, and discretionary approvals were in fact required, including a special permit to modify dimensional criteria. No discretionary approvals were required for the boarding component of the facility. Again, this is the same underlying zoning district, the AAA zoning district, as is the property in question before the board tonight. That proposal included the construction of 4 new dormitory facilities that is outlined and memorialized in the exhibit I provided you. It follows that my client's application should be treated on equal terms and in the same manner as that of the Harrow International School. If it was the drafter's intent for dormitories to be, by default, a town board action, the town board had a chance to hear that relief 1 year ago and chose not to. In my view, I would respectfully suggest that this is prima facie evidence that counters Mr. Bertolino's assertion that by not including a boarding school reserves the right for the town board to hear it. The applicant's contention that the boarding school component cannot qualify as a permitted accessory use would effectively nullify the town code's accessory use framework. Section 8648J expressly permits accessory uses that are incidental and subordinate to a permitted principal use.
Can I ask you this question so we can boil this down? Are you saying that since the town permitted a secular school, boarding school, to even increase their dorms and permitted it and it's up and running, are you basically saying, how can we deny this application? Is that where we're headed?
Yes.
That'll be a question for the team Bertolino, Campanelli. I mean, that you do present, it does present a conundrum that if the town granted the same in a AAA, much larger, 6 miles from here, how do we deny it on this? It's an interesting question that will have to be addressed.
I went there.
But it is a resident, it's a AAA area. It is.
Whether or not,
When you're on that campus, you're not even like, you're not even in the same state as the residential community.
it's not, you're nowhere near it. So it is different, but I understand your argument.
Sure. Whether or not you can see the dormitory or boarding facilities from the street does not negate the fact that both parties must be treated equal under the law. And the town board had the opportunity 1 year ago to say that a special permit was required for boarding facilities, and they chose not to. With that being said, I'd like to additionally mention that if the town code drafters did not contemplate accessory uses of this nature, there would have been no reason for the drafters to include Section 8648J to begin with. The board should therefore give effect to the plain language of the provision as written and recognize that boarding facilities are permitted accessory use. In determining whether boarding is a use that is customarily and incidental and subordinate to a parochial school, it should be noted that religious and educational uses enjoy special treatment with respect to zoning ordinances because these institutions presumptively serve the public welfare and the public morals. Religious and educational institutions are generally permitted to engage in activities and locate on their property facilities for such social, recreational, athletic, and other accessory uses as are reasonably associated with their educational purpose. Boarding and dormitory uses are customary components of religious schools in accordance with applicable New York State case law. In a similar case as the instant matter, the Appellate Division, Second Department, has held that dormitory buildings is a customarily incidental use to a primary religious high school, and that a use variance would not be required for such use in a residential district.
What?
How do you compare that with the statistics that show 97% of the parochial schools in New York State are not boarding schools? How do you then say that it's customary use when it's clear 3% of them? It's customary to 3% of them.
I haven't,
I understand
sure.
your case law point. I get that.
Sure.
Help me
Sure.
understand how to synchronize these two.
I understand. At the end of the day, while I haven't had the opportunity to review the statistics, the facts on the ground doesn't necessarily equate to the law. And the law says that dormitory facilities are a customary incidental use to religious high schools. It is very clear, and
I don't know if it's very clear, but that's your position.
sure, it is my position that it's very clear.
Can you provide us with the citing on that? Provide us with that site.
The site has been provided in the memorandum of law in your exhibits package.
Do you want to give it, to put it on the record?
Yeah, sure. Association of Zone A and B Homeowner Subsidiary,
Oh, okay.
Inc.
Yep.
Long
No, we
Beach,
have that.
the Long Beach
Yep.
one, okay.
Yes,
That's
sir.
the Long Beach case.
Yes, sir.
Thank you.
That's the second department.
Here, boarding is a critical component of my client's proposed religious use, as the residential boarding component supports the United American Muslim Association's mission to foster a comprehensive spiritual and academic training of its students. With that said, while it's not before the board, from a land use, zoning, and planning perspective, the proposal before the board is a significantly lower impact and lower intensity use than what could be allowable on the site, given the building, its configuration, and the zoning code.
What could be allowable on that site? I mean, I know, but let's make a record of it.
Sure. A church, mosque, or synagogue is permitted as of right on the site, given the size of the building, nearly 70,000 square feet, according to the architects of record. That's an occupancy load of over 1,300 individuals. With a 14-acre site, there is ample space to meet all of the town's land and development standards for parking, screening, buffering, etc. So again, while it's not before the board, it's our position that this proposal represents the most responsible use of the property, has very low traffic, as the students will not be allowed to have vehicles on campus during the academic year or at all, and we'd be happy to stipulate to that in the administrative site plan approval if it proceeds. Minimal traffic, minimal parking, minimal noise, minimal occupancy. So from a land use and zoning perspective, we feel this is a responsible use of the property in alignment with the history of the site and that the plans examiner's determination reflects a reasonable and textually faithful application of the code as it's written. It correctly recognized that the proposed parochial school is a permitted use and that the boarding facilities are a permitted accessory use because they're incidental and subordinate to the school's educational mission. We would respectfully ask that the determination be upheld as it's in accordance with the town code, New York state law, and federal law. Thank you. Mr. Sullivan, I do not have the answer to that question.
Try it, turn it on, turn yours off.
So you don't have an answer for that?
I do not, sir. I do not. I mean,
They don't know
I
who's
can
gonna be
confer with my.
they don't know if they're gonna be staying there all summer
I mean,
long,
I
or year-long?
imagine, just based off of logistics and operations, it is a very large building. Without speaking to my client, I can tell you that, yes, I imagine there will at least be several individuals who are going to reside in the building over the course of the summer for
But
maintenance.
They're not gonna have school over the summer, though.
Correct. For maintenance and upkeep of a building that size, I imagine there would be at least,
I'm just talking about students.
Sure.
Is school in session all year, or just the academic year?
just a traditional academic term.
Okay. And my other question is, that it went to an earlier point by Mr. Bertolino, I believe. The cost of the school, the tuition. Do you have an idea yet? What you're going to charge just for the school itself? Because there's people that are going to be coming there for the school that aren't going to be boarding.
Right, are you gonna have day students?
No. The proposal before,
100% boarding?
correct.
Okay. And what's the cost? What is the?
I don't want to commit my client to any
give me a
particular
roundabout
cost,
cost.
but somewhere between $750 and $1,250 per month, which is going to cover academic and boarding-related expenses.
So for $1,200 a month, they go to school there and they stay there boarding-wise, and they're fed and everything else.
For 10 months a year.
Approximately.
So somewhere between $75,000 and $120,000 a year?
No, it's a month. That would be.
No,
Yeah, it was
$1,200 a month,
10
they're
months.
open for 10 months a year,
10 months a year.
$120,000, right?
No, approximately between 10 and 15,000
1,000 a year.
per
Oh,
year.
okay, yeah, all right, well, I'm a lawyer, not a mathematician, I don't know.
Do you break down the academic cost versus the boarding cost?
I'm not prepared to speak in detail.
Well, I think that's important for what you're asking for here.
Regarding the cost. It's one factor that was outlined by the board. Again, the United American Muslim Association is a nonprofit institution. There's generous scholarship offered to the students who are going to be attending the school. A building of this size, it was recently reported in Newsday, a building of this size costs tens of thousands of dollars per month simply to heat, fuel, landscape, water, et cetera. So, just given the property taxes, given my understanding of all of those associated costs.
Folks, please let him speak.
What I'm trying to get to the point that I think it was made earlier was that the percentage of the cost for the boarding school versus the actual education and the academic side of it. Because I think that goes to a lot of whether the boarding is an accessory use or more than that.
Is it the moneymaker?
Or is it the moneymaker? That was brought up earlier, and I thought that was a good point, and you're telling me you don't have an answer for that.
I do not have an answer as to the breakdown. Costs are going to have to be paid for the upkeep of the building. The building is there to
Well,
support.
that's not my question.
Sure,
My question is,
but
what percentage of the money is going to boarding versus academics? Because I think that makes a big difference in how we decide which is the more important use of the property. Is it the academics or the boarding?
I understand the question that you're asking,
But you don't
Mr.
have an
Sullivan. I do not have a breakdown, but what I can say is that there is tremendous expense with the upkeep of the building. The building is there to support the educational mission of the academy. There's teachers' expenses, there's food, there's many expenses.
You mentioned
that
property taxes. Is this subject to property taxes?
No.
Okay.
Can I ask you a question? We heard numbers, and I guess they're correct, of Stony Brook School is $70,000 per annum. I'll take Mr. Campanelli's word at that. So you think that this will come in and it's only going to be boarding students, will come in at about $15,000 a year?
That is the information that I was provided, yes.
So it's not self-supporting then? Are they getting money from, which is fine. I mean,
Correct,
I'm
it's
I'm
not,
just-
it's not self-supporting.
I'm asking that question because there was a representation that the dorm was going to be this huge moneymaker, and that's why I said, you're speculating, and if you're telling us the tuition is going to be $15,000 all in, room board tuition, that's something that I think we need to consider.
Mr. Wexler, we stand by that figure, and you're correct, it doesn't fund itself. There's
can't.
there's
You do the
tremendous
math, yeah.
funding that comes in from the members of the community through fundraising programs,
Sure, okay.
as is accustomed with.
All religious
Correct.
institutions.
There
There are
have
none that make a profit.
Correct.
That I know of. Okay.
Catholic Church is very profitable.
Any other questions for Mr. Westphal?
No, not for me, thank you.
What about the accessory structures to the school and to the boarding? Like cafeteria, food delivery, laundry services, air conditioning units, heating units, other things that are going to create traffic, noise, delivery trucks, and everything else that may be coming in and out of there to serve 200 and change people living there?
Sure. So, third-party vendors are expected to be limited. They're expected to be during normal business hours. That would be, refuse pickup, twice per week, food delivery 1 to 2 times per week. And we would submit that these traffic impacts and other related inquiries are low impact and low intensity. It's going to be very much a self-sustaining campus. Of the 20 or so administrative faculty and staff members who are going to reside on campus, many of them are going to handle these types of obligations and responsibilities traditional to a school. For example, laundry takes place on campus by administration, faculty, staff, and students. So just using that as one example of a third-party vendor that will not have to come to the campus. Landscaping. It is anticipated at this time that landscaping is going to be handled by one of the residences, the administration, faculty, or staff who are going to live on campus. So you're not going to have landscaping
They're going to
trucks.
cut a 14-acre lawn every other day?
Yeah, absolutely.
They have to do that now anyway.
Let me just
More
add-
power to them.
Just following up on Sullivan and Messrs. Sullivan and Nicolia, the traffic, I'm just trying to, none of the students in boarding schools don't allow students to have cars, so that's.
What's the point if they
that's-
can leave?
Yeah, right, they don't want the liability, that's the reason. That's the first thing. So there are going to be 20 teachers and administrative staff that live there.
There'll be approximately 20 administration, faculty, and staff members who reside there.
They'll live there, okay. And they'll
Correct.
probably have a car, but then it's not 10, 20 trips a day they're making,
Correct.
theoretically.
And approximately 10 additional teachers who
Okay.
will commute to the
So
campus.
there'll be 10, so I'm just trying to get an idea.
Sure.
What is the number of trips? I know planning engineers like to say trips.
Sure.
Or what's the vehicle or vehicular traffic that you are anticipating? I get it, the students aren't driving, the staff of 20 lives there, there's 10, I just want to get the entire
Sure.
universe. So
If-
there'll be 10 teachers.
10 teachers, 20 administration, faculty, and staff who live there, so let's put that at 30. And let's
Well,
be
it's just those that are going to be commuting every day.
So then
That's what I'm concerned.
commuting every day, it's just 10 teachers and then several, occasionally you'll have your refuse pickup, occasionally you have your food delivery. So in our view, 10 to 15 on a day, maximum.
Right.
If you'd like to incorporate administration, faculty, and staff who may come and go on a given day, it could be 20 or 25, which again, while a traffic study was not done, we would submit that's a lower traffic use than what could be permitted under other circumstances.
So the universe would be basically those 10 teachers that commute, various vendors, I don't know what vendors, food, textbooks, whatever. I mean, it's not anything else I'm missing. I'm just trying to figure out what the total traffic use will be.
Correct.
It doesn't sound, anything else that,
There's nothing else that wasn't highlighted. We do not expect a serious traffic impact whatsoever.
right, they're not dependent on like a convenience store of 150 people a day coming in and out. It's okay.
No.
I think I have one more question. It was brought up by one of the attorneys
Oh,
on the
yeah.
other side. How many dorm rooms are there?
Sure. So there's 24 bedrooms on the second floor.
So, okay.
Okay, so we're proposing 5 students per bedroom. That's 120 students. That's where the 120 student number comes from. And then there are 23 bedrooms on the third floor, which we're proposing, the overwhelming majority of them will be utilized for the administration, faculty, and staff are going to live there. We're estimating that to be at about 20. So of the 23 bedrooms, we're expecting them to be occupied by employees. And then there'll be several additional bedrooms that are left.
And just I asked, so I'll be fair, I asked, I think Mr. Bertolino or Campanelli, these questions that we have to focus on, whether or not it's incidental, and I'll let you make a record so we know. First, other than the faculty, staff, and you said the guests would be, and you'll commit to this, will be parents and visiting, we'll call them dignitaries, okay. That's it. So there's no outside rental, correct?
Correct.
And not even those staying there, other than the students, will be paying rent, correct?
Correct.
And that will be committed to you by your client,
Correct.
Okay. The right to live there, other than the staff, the students, when they graduate, it ends, correct?
Yes, sir.
They can't say, I want to stay on and live, okay.
Correct. Limited to students
And
only.
a certain number that all schools have kids stay over the summer, but that's, what do you suspect? 5, 10 kids will stay there? Are they even air-conditioned?
Certain rooms have air conditioning facilities.
Okay, but how many do you think will stay there?
A finite amount over the summer. There are no,
Approximately, so we know. We have to make determinations. Are they going to be 20, 30, 40, 50? You must have an idea. You're building a school. Approximately.
not more than 20%.
Okay. The school owns and controls the facility, correct?
Yes, that is
No other
correct.
agency okay. The school will set rules for the dormitory students?
Absolutely, yes, sir.
Let's see, same question I asked, does the dorms of the residents support the educational facility or program?
Yes, they do.
Could you have a boarding school without the dorm?
No.
Okay, and is the occupancy tied directly to the school enrollment?
It is.
Okay, thank you.
Thank you, Mr. Chairman.
One more. You closed last month, correct, on the property?
Yes, in June.
And then that's a full closure, not condition deed, not a,
It is a full closure. My clients own the property outright. There was a post-possession that ends next week to allow for the Montfort community to get some of their belongings out of the building.
but it's not conditioned on any land use?
No, sir,
determinations?
it is not a subject to transaction. My clients own the property outright.
Okay, thank you.
I'm sorry, I neglected, just so we know, what was the ratio, or what is the ratio of dorm to the rest of the facility? Percentage-wise, square foot,
Approximately 33%.
30%?
dorm or facility?
Approximately 33% is dormitory facilities.
Well, did you give us that breakdown before, 22,000?
Yes, sir. Yep.
Roughly? Okay.
Approximately 22,000 of the 68,000, roughly, is designated and earmarked for sleeping quarters. The rest is other facilities that are normal to an educational facility, such as classrooms, labs, lounges, et cetera.
Thank you.
Okay. No more questions at this time? All right, Mr. Bertolino, you said you had some people that you wanted to have come up and speak?
Thank you for your time this evening.
Mr. Chairman, if I may, I also asked for a little bit rebuttal.
Not at this time. We're going to let, you said you had other people you wanted to have come up?
Yeah.
We'll have them speak, and then
I'll be very, very fast.
we'll have them speak first, and then if you want to speak a rebuttal after that.
Okay, no problem. Yes.
There's a few of them, you said.
I had asked for the opportunity to quote-unquote name or call the first few speakers, just because I don't want to get certain viewpoints cut off
Okay.
if this board decides to cease public comment. First, I'd like to call up Doris Kennedy.
Okay.
Next in line would be Joanne Genovese, if you want to get yourself on deck. And after that would be Lori Berger.
They understand that they want to keep them on point here?
Yes.
Good evening. My name is Doris Kennedy. I reside in the immediate area of the peninsula, just a couple houses away
Could
from
you give us your
the
address,
property.
please?
18 Green Avenue, Bayshore.
Thank you.
First, I just want to mention, I've been a resident of the neighborhood for 30 years. I can tell you I've passed this building multiple times every single day over the 30 years. People are going to argue, especially after the Newsday article, that a precedence has been set, that it's been a boarding school. In the 30 years that I'm there, I've never once seen it operate as a boarding school. The assumption that it's been a continued use is just not a fact. History bears no continuity in what's been happening there. The facility has pretty much remained dormant. You'll see occasionally people come by mass cards. You'll see an occasional retreat on a weekend, the annual fire department picnic in the field, and that use has even diminished more and more over the current years. So to say that they've been having multiple elderly priests living there for years, I can tell you in 30 years that I'm there, I have not once seen an ambulance come to the property, so I find it hard to believe that they've had multiple elderly people
Priests can
living
be
there.
healthy.
Well,
Get a deal.
I'm kind of going to go away from what I planned on talking about because I have some questions that have come up based on both parties and your questions. So the first things I ask is, you're reading something about accessory use being automatically granted to them. Can the town tell me in any New York appellate decision holding that every parochial school has an automatic right as a boarding school as an accessory use?
We can only deal with the property in Islip Town.
Okay, but you're quoting something from New York State, you said, stating that it's
Yes.
automatically guaranteed.
No, I was quoting from the appellate division. The appellate division, if we were to be appealed, whatever we decide, somebody would take what's called an Article 78 to
Correct.
the Supreme Court, okay? Above the Supreme Court is the appellate division. They're higher. The highest court in the state of New York is the New York Court of Appeals, but they don't take many cases. So the appellate division is generally the end of the road. They're the controlling court. The appellate division, we're in the second department, so that's the
Okay.
controlling court. The appellate division has said that a boarding or dorm is customary or custom in use or incidental and customary to a religious school. That's the law. I take issue with Mr. Bertolino and Mr. Campanelli. They're very good lawyers. This is what lawyers do. We argue over the meaning. But I'm saying that's a direct quote from the courts that we must follow. That's the law. So I'm not saying in every single one, but they have rendered a decision that said it is a customary use, whether we like it or not.
But
whether
only
they
for
like
a
it.
religion, for a religious school is what you're saying.
For a religious school, yes. I'll give you, hang on. I'll give you the exact quote. You ask a good question. Are you a lawyer? All right. Here it says, the second department has held that a dormitory building is customarily incident to a primary religious school, high school, use such that a use variance would not be required for such a use in a residential zoning district that permits schools and places of worship.
And
So
what year was that
that
established?
was 2002. So that has not been reversed. That's still good law. I'm telling you, that's the law.
So there was a case in 2019, Northwood School versus Joint Zoning Board of Appeals, where they adhered to town zoning, and it was successful, and the appellate court stood by that. So I just
you'd
would
have
like,
to- if
you know,
you have
that
this-
noted on record, that might be something
If you
worthwhile
have-
checking.
That you want to submit it to the record?
Or do you have the
I'll submit it
cita-
tomorrow.
Do you have the citation?
No, if you can submit it tonight, otherwise.
If you give us the case, we can review it.
Okay, the Northwood School versus the Joint Zoning Board of Appeals in
Can you
2019.
just spell that? versus what zoning?
Northwood, Northwood, School versus the Joint Zoning Board of Appeals in 2019.
Do you have the site other than that?
I don't.
Okay.
Sorry.
Well, we will look that case up.
So now I want to go over to the town board and the zoning codes that you set forth. I know we did touch on it earlier, but so the town created these laws for the community to follow. I know when I go to town board for stuff, they're very strict, what's here is written, and that's it, it's cut and dry. You're saying one thing that you just read to me, but just so for the business district, like we talked about, it specifically says that a church or school is permitted. If you look in AAA, same thing, exact same thing is permitted in that code. When we go back to business, the BD district, it says use is permitted by special permit from the town board. And it specifically states a permitted use is a college dormitory, similar residential use for housing. Then it ends with prohibited uses. All uses not expressly permitted in here in your own code are not permitted. When we go to residential AAA, which is what we're talking about now, like I said, we still have that same church that's permitted. It specifically says in the accessory uses that it allows for a parsonage. If anybody doesn't know what a parsonage is, I will share that with you. A parsonage has long been recognized as a customary accessory use to a church, which would be similar to a rectory, and it operates for a member of the clergy or their family to live on the premises. So residential A says you can have a school, you can have a church. We're allowing an accessory use for a clergy to live on a small property, but nowhere in here whatsoever does it say as an accessory use or a right of use or with a special permit, a boarding school. So
What section are you quoting
as far as
for residential A?
residential A, if you look under,
Is it 6845?
Is it 6845, AAA
It's AAA.
zoning?
6845?
6847, no, 6848, accessory uses,
6845 allows for parochial schools.
correct.
That's residential A.
Yeah, I'm not
AAA.
disputing that it allows
Okay.
for a school. What I'm
And then
disputing is,
6848 allows for accessory uses, and that's why we're here tonight.
right, but in the accessory use, it states a parsonage, which is a rectory for a priest or clergy for the school or church to live on the premises. So you're saying, okay, you can have your priest, your teacher,
Yes,
that
we're
type
not,
of.
we're not here debating a parsonage, but we are
Right,
debating,
but if you're stating in here that this is an allowable use, but you're not stating anything to a dormitory, and then your last line in your own code says, if it's not, hold on. Here's the wording. So
yeah,
the wording is-
6848, that's why we're here tonight, ma'am.
I understand that.
Can I-
but
can I-
your code says you can have a church, you can have a school, you can have a parsonage, but it does not state anywhere that as an accessory use with a special permit or under any circumstances is a boarding school.
Can
Then
I just-
why would
can I- hang on,
BD
can I ask you a
state
question?
You could have a boarding school under
Can I-
certain circumstances.
Can I just, okay, you ask interesting questions and you point to interesting areas of the law, but what happens is, first of all, the code does not say you cannot have a dormitory, so let's get that out of the way. And what happens is, it lists the things you can have, okay? However, this happens all the time and we have to deal with it as lawyers. The code is written, let's say 1972, 73. Since then, the courts, which direct, they control, they state that we determine that it's an accessory use. That doesn't mean that the code written 20 years before that decision, the court always supersedes. They can strike down a code, they can amend a code, they can amplify a code, they can harmonize a code. So what happened, and this happens, and again, for your edification, you ask a good question. The code was written, let's say 40 years ago, and it set out the parameters. Since then, the higher courts have said no, and we determine that theoretically, towns and villages could, every time the court rules on every case, run to amend their code. They don't. What they do is they have their, eventually they do, but they have their existing code, and they have to deal with what the courts tell them. That happens all the time when the United States Supreme Court rules that may invalidate state, town, village codes throughout the country. The Islip or the Brightwaters or Ocean Beach couldn't say, we don't care about the United States. No, they can change the code. And it's not called changing it, but they are amplifying it, and they are giving us directions that we have to follow. We can't say, no, look, this code written 40 years ago, that controls. They'll say, where'd you go to law school? So I understand your concern. You're reading the code, and you say, aha, it doesn't say it. The courts since then have said, no, this is a customary use. So it's, the town code is superseded.
Okay, so,
I know that was long, but I
no,
wanted to
that's
understand.
okay. If 100% of the use of the school is boarding, 100%, not one student there is not boarding at the school, how is that an accessory use? That's the primary
No,
use.
the question is whether boarding is accessory to the school.
Okay,
So the school is a use and boarding is an accessory use.
right, but that's a 24 operation versus a 6-hour school day, but how is that accessory? And
The
not
courts
more of a
the courts have
subordinate
ruled.
use?
The courts have ruled it is, whether we like it or not. And
I
that
mean, in
happens.
short, you're putting your finger on, that's the question tonight, that's why
Yeah.
we're here.
Right, I understand
With
that.
all these
So we
fancy
understand that as
lawyers,
well.
you hit the head on the nail. That's the question. The court has directed
Okay,
that
so
that is a customary use, whether we like it or
We
not.
understand your question, and that's why we're here tonight.
Yeah,
I think also, I wanted to chime in, I
Please.
think I understand what you're saying is, that you're saying 100% of the use. We received testimony today that it's only 33% of the use would be of the boarding facilities. So not 100%, 33% is what,
Right, of the facility,
boarders.
but not of the students attending it.
Well, it's a school, so the 100% is the school.
Right, but not everybody
Okay.
always,
We can keep
boards,
dancing all night.
students, local students, when you go to college,
Is there anything else
drive
you'd
local.
like to say?
The Harrow School
Yes.
that you talked about, were they granted the boarding school before or after the overlay was added to the zoning?
I'm not even sure.
What was the question?
The Harrow School that was granted the
Oh,
boarding?
I know what your question is. The AAA existed there long before the Harrow School.
Right.
The AAA goes back to, what, the 70s?
AAA was
AAA's
only
been
invented
there
in
for a long time, yes.
1962.
So it goes back.
That's been a boarding school since 1926.
Yeah.
So that, the AAA designation goes back to 1962.
Okay, so
Predated by years.
their boarding really didn't set precedence then, it was based off continued use, correct?
I don't know if there was a break in use. I believe he's a LaSalle. Are you a graduate or?
No, they closed.
Oh, they closed.
They sent me to St. Anthony's.
I don't know whether or not, and again, it's not before us, whether or not, I believe LaSalle was closed for a number of years. They didn't close in
It became a
2004.
college afterwards.
Yeah.
And it was owned by St. John's, and there was something else.
So,
I don't know if there was a break in use.
Yeah, there may have been, we don't know.
But we don't know if that was granted after the overlay was added to it or
But it's
before?
not the overlay that controls, it's the AAA. It's AAA zoning.
But I thought
Predated.
that the additional zoning is what permitted them to have the boarding there.
That's, so as far as I understand, that would not be correct.
No?
The overlay adds a lot of things that they are, in theory, allowed to do now. It modifies the AAA, but the only modification that happened was allowing for height of buildings, et cetera. As far as the use as a boarding school, that was not addressed in the change of zone. It was not pertinent at the
Got
time.
it.
Anything else, ma'am?
Nope, that's it, thank you.
Thank you very much.
Thank you. Actually, you asked very good questions.
Please don't applaud for each speaker. Be all night. Mr. Bertolino, who's your next suggested. Me, hello, me.
I thought they were lining up, sorry.
Good evening, may you speak into the microphone and please give us your name and
Sure.
address?
My name is Joanne Genovese, and I live at 22 Joyce's Way in the Windcrest Retirement Community.
Okay.
And the back of my unit borders the Montfort property. So I have a deep interest in all of this. The community I live in was built in 97 and 98. It was built as a planned retirement community. And I understand at the time it caused a ruckus in the AAA. But we are a very 43 units, quiet, retired people, no clubhouse, no pool, just houses. And we actually bought the land from Montfort. The builder, it was the ball field. So it was originally part of the Montfort property. And the people in our community, most of the people are original residents, longtime Bayshore and Islip residents. The community's been around for almost 30 years. And for that 30 years, Montfort has been behind us, and it hasn't been a boarding school. It really barely was even a seminary for that time. They had a handful of priests and an occasional retreat. I mean, so this has been a very quiet neighbor. We have birds, and we see the pond, and there's wildlife, and it's just a peaceful, beautiful spot. To bring in a boarding school is going to create a 24/7 noise, a disruption, an institution next to us that nobody's had in all these years. And I was very curious, why? How did this come up about the boarding school? Because ever since I've known Montfort, it hasn't been a boarding school. You heard that maybe it was. So I looked it up. I know they've been there since 1927. They were operating. They were there in probably one of the mansion houses. They've acquired the property through the years. They acquired, I don't know the original piece, it's probably back in the microfilm in the 1927. They acquired part of the Hawkins estate in 1952. The ball field that we were on got donated in 1938, or sold for $1. So they acquired property through time, and in the beginning operated out of the mansion house. And they did have some young boys living there. I don't know how many they could have had. It doesn't say. It's way back in time. They had some. They did live there. They were using it. At the time, it was a fashionable thing that boys who wanted to become a priest sometimes went to the boarding school to think about, live with the priests, maybe to help them make a decision if this is the life they wanted. And so they were that. And then I found out that in the building that they are in now, that building was built in 1962. The construction began, probably completed in 63. Montfort had hopes of growing the boarding school, having a larger boarding school, to be self-sustaining, to get enough tuition, as we've been talking about all night, to sustain themselves on that piece of property. Well, I looked and I found that the Islip Uniform Code, zoning code, was not in place in 1962. According to what I researched, it came in 1967. So when it came in 1967, Montfort was already there, operating in some capacity as a boarding school. Montfort now found itself in the middle of AAA zoning. Now, I've read the AAA zoning that's online. I heard what you said, that things change and life changes and it's not in the code. But the code, as I read it online, did not allow for a boarding school, and it didn't allow for that as an accessory use. So what it appeared to me was that the town granted Montfort a use through special permit since they were already there. The town did not include boarding school in the code because I felt that the town realized it's a different entity when you're talking an institutional dormitory school in a residential area. So for the since 72 through now, they occasionally housed priests, they occasionally had a retreat, and the house has not been used as a boarding school for over 50 years. So how can that count as something we need to consider now, when the code itself did not look to umbrella it, and they were there when you put the code in? I mean, I'm sure when you put the code in, they said it was a piecemeal code up until then. I understand that on the Point, the big estate on the Point used to have a farm and farm animal. I mean, we didn't put that in the code either. Places move forward, and why are we in this position that we have to be retrospective about how we use that building? The other thing, I mean, that's the thrust of it. I mean, there was other things I was going to say, but it's been so bantered about tonight, all the legalities and all the things have come up. I'm trying to understand. Now, my peace and quiet in my backyard is really, and there's 10 units that actually border on this side. And let's face it, the whole area. This is a dramatic change to what has been there for a very long time.
I agree with you. However, and regardless of what happens tonight, you need to accept the fact that this is a very valuable piece of property south of Montauk in Bayshore. Something is going to happen there eventually.
Something what?
Something is going to happen there one way or the other, whatever, regardless of what we do tonight. That property.
No, I do understand that, but you know, the other thing that what I found, I mean, there's, you know, along the Great South Bay, they write about this area. This was your Gold Coast in this town. So now to just not, we also have very large parcels down the block. We have several. Is this what we're going to become? This is a beautiful spot with great boating, and it's just lovely. And I could cry, frankly.
I understand your frustration. I really do.
I mean, there were other things I was going to say, but they're pointless, frankly, after everything that's been said.
Nothing is pointless. No decision is made.
No, so let me understand then. There's still room for a decision to be made on this topic, and does it at all count that there could have been no permit in place? There could have been no, and I know you're talking about where the former LaSalle and the new school there. That's a very different, it's on giant property. It's not sandwiched in between all these houses. Well, I can tell you, coincidentally, I'm the president of our HOA right now, and that doesn't mean anything. But when we had our annual meeting, I have never seen so many, and they're elderly at this point. I've never seen so many residents get so upset. They have lived, well, for almost 30 years in this place and in the town for so long. They are long-time town residents who have deep roots here. I've never seen so many upset people. So I really ask you to please deeply consider what this is going to do to the neighborhood and the door it's going to open in the future for what else is down the block and in the area.
Please, no grandstanding. Mr. Bertolino, do you have somebody else you'd like to have speak? Mr. Bertolino?
Yes, I just have one more.
Good evening. I just have a statement that I'd like to get on the record. Good evening. My name is Vanessa DiDomenico. I live at 125 Awixa Avenue, and I ask that this statement be entered in full into the record.
Ma'am, if you could just speak slowly so that...
Sure. I feel like him. Full into the record of application, number 533-26. The board has suggested that a dormitory for roughly 140 students can become into a AAA residence district as an accessory use to a school. The town code answers that suggestion directly in 3 ways. First, the code's own definition, section 68-3, requires that an accessory use be customarily incidental and subordinate to the principal use. That is a conjunctive test. Every element must be satisfied. Subordinate fails on this application's own numbers. 47 sleeping rooms and about 140 people living on site 24 hours a day, 365 days a year, measured against a school day of about 6 hours. By floor area, by head count, and by hours of operation, the residential use is the dominant use. When the tail is bigger than the dog, the tail is not an accessory. Second, customary fails, and the proof is the code itself. The town board has legislated on dormitories 3 separate times. Section 68-287.1a, Section 68-624.1, and Section 68-324A. Every single time it made the dormitory a principal use. Every single time it required a special permit, and never, not once, in any residence district. In fact, the editor's notes to Sections 68-47 and 68-48 show the town board repealing school-related accessory provisions over the years, not adding them. Whatever may be customary somewhere else in the town of Islip, the custom is written down, and it says the opposite of what the applicant needs. Third, the code closes the door by definition. Section 68-3 expressly classifies a dormitory as a multiple dwelling. A multiple dwelling is not a permitted use in residence AAA, and Section 68-47.1 states that all uses not expressly permitted are prohibited. A use the code has already named, classified, and confined to special permits in business and industrial districts cannot walk back into a residential neighborhood through a general accessory clause. If it could, those 3 special permit sections would be meaningless because anyone could avoid them by attaching a classroom. And consider what the accessory theory would mean. The code requires 100-foot buffers when a dormitory in an industrial business district abuts a residential lot. Under the theory before you, my neighborhood, the most protected residential district in this town, would receive less protection from a 140-person dormitory than the code gives to the neighbors of an industrial park. There is no limiting principle. If 140 residents are incidental, then no number is not. The applicant's own letter of use concedes that this use is not enumerated within the town code. That concession is correct, and under 68-47.1, it is dispositive. One more point. The case the board mentioned earlier, Baker against the same zoning board, decided by the appellate division in 2005, supports the neighbors, not the applicant. In that case, the court reversed this board because it read words into the Islip Code that were not there. The court held that the code must be given its ordinary meaning and, quote, may not be extended by implication, end quote. That is exactly what the accessory theory asks this board to do again, to extend the words parochial school by implication to include a 140-person residential institution the code never mentions. Baker also holds that a zoning board's interpretation of the code receives no unquestioning deference from the courts. The ultimate responsibility for interpreting the law rests with the court, and the court will read the words as written. This board should do the same. I respectfully ask the board to reverse the January 21st, 2026 response to zoning inquiry and to hold that this issue is not permitted in residence AAA by any pathway. Thank you.
Please, no applause. Mr. Bertolino, is there anybody else you'd like to have speak?
I'm sorry, Mr. Chairman, I didn't hear you.
Yeah, I couldn't hear myself either. Is there anyone else you'd like to have speak?
Not on my direct behalf, but I'm
Okay.
sure the audience
Would
has
you like
something-
to say anything before we open
Say
up?
that again?
Would you like to make any statements before we open it up to the floor?
Yes, I'd like to just rebut,
Okay.
if I may.
I'm sorry?
I will be quick, Mr. Chairman, I promise. So, Mr. Bifulco, once again, has handed me all the ammunition I need. He's asked for parity. You threw me before when he said this Harrow School. I didn't know what it was, because like here, the application was made in a different entity. My understanding that what we've been talking about was under an application made by the Amity University, Inc. for the Oakdale campus, which is the LaSalle campus. I have that decision here. We may be different than them, but the point that I've been making all night is right here in front of you. It was before a town board public hearing that any determination on that property was made. It wasn't an administrative site plan approval. That's not what we're about here. With respect to the code and the Baker decision, and you come down and say, well, we have to adhere to customary. It's customary. The courts have decided that. But there's another test. It's the incidental test. Mr. Bifulco set forth that 22,000 feet out of the approximately 70,000 square foot facility was for residents. My understanding is there's 3 floors. He submitted, and I submitted as well, the site plan, the proposed site plan, existing site plan, whatever it is. 2 of those floors are bedrooms. What I heard from Mr. Bifulco tonight, one of those floors was dedicated to students. The other floor, the other bedrooms, were dedicated to staff, visitors, guests of unknown nature and kind. So how did 22,000 square feet on one floor become the standard when you got 2 floors? To me, that's about 44,000. To me, that's 2/3 of the total, not 1/3. How that got turned around, I don't know. How the board didn't catch it, I don't know. But when you've got 2 full floors, assuming the floors are of equal dimensional proportions, and 2 of those floors, as I see you're looking, 2 of those floors have the dormitories, the bedrooms on them. Interestingly, when I looked at that floor plan, I noticed that bedrooms were specifically called out on one floor, but they weren't on another. And that's okay. I was wondering why that was. Maybe because some of the rooms had beds in it, some of them didn't. So do you call it a bedroom if it doesn't have a bed? But the question was answered tonight by Mr. Bifulco. He told us that other floor, be it the second or the third one, is going to be dormitories for guests of unknown nature and kind, for staff, and for visitors and parents, whatever it may be. But it is still a dormitory. Do the math, and we're at 2/3, not 1/3. Mr. Bifulco stood here and said this was promotional material put out by my clients. Mr. Wexler inserted the word repudiate. Yeah, you pulled it back. It's still on the website today. I challenge anyone on this board, pull it up on your phone. It's still there. They knew weeks ago that we were bringing this forward, and they still left it up. So I just want to read one paragraph of an email that I sent to the planning department asking them to hold their decision item in abeyance until this hearing was done. In multiple public messaging videos, the underlying applicant, not the attorney named of record as the applicant, boasts of 14 guest rooms, event space, 7,300 square feet of terrace space for outdoor events, and specifically of hosting weddings. I'm not certain how young boys in a parochial school can legally wed each other, so the only explanation is that the applicant is not being truthful to the town of Islip, or this religious organization is not being truthful.
Once again, no grandstanding.
I'm not grandstanding.
You are, when you're pointing
I'm
and
telling
getting a
them to
reaction
stop.
from the crowd.
I'm asking them to
They're
stop.
not listening to you.
Mr. Vitaliata, on behalf of the applicant, myself, I don't condone what's happening. I'm asking them to stop.
Please.
To finish that, the applicant is not being truthful to the town of Islip, or this religious organization is not being truthful to the public and or its constituent members. It's one or the other. You don't get to repudiate. You don't get to have it both ways. You can't leave live on your website what you want to do to raise money and then come before the board and say, oh, I didn't mean it. They meant it. And what I'm telling you is this is more than just customary use. Islip drafted its code, as I set forth before, and they specifically designated when, how, and where, in what districts you could have a boarding school. It's not here. And if you want to have one, do what they did in Oakdale. Go for a change of zone. Now, I may be out of line and I may be wrong, but I was told when I was given this decision, I was told that the town, perhaps the planning department can weigh in, requested, demanded, whatever word you want to put on it, you go in front of the town board for a change of zone, or...
Who told
do we
you
have-
that? Who told you that? Give us the name.
J.R. DeCiccio. I believe he was the one who represented them, from Greenberg Torig.
He hasn't been associated with the town for
I didn't say he was
3
a town
years.
board member. I never said he was a representative of the town.
Oh,
I said the person who gave me this decision.
Oh, so some other lawyer, J.R. DeCiccio,
Some-
gave you a decision.
He was the applicant's lawyer.
All right, but that doesn't bind the town.
I didn't say it did. All I'm saying is, once again, Mr. Bifulco wants parity, we want parity. Town board hearing at the very least. Thank you.
Thank you, Mr. Berlino. All right, now we're going to open one at a time. You've heard what we're talking about tonight, ladies and gentlemen. It's basically on the one issue of whether or not this is an accessory use. So we'll ask you to come up. You're going to state your name and address. We don't need you to keep repeating things. We understand what the area is and how it's been for years. So one at a time, please come on up and just form a line behind the person speaking.
Don't line up. Just, you guys are going to raise your hand.
Yeah, Jay doesn't have...
Oh, okay, thank you, Jay.
Can you hear me?
Stay in your seats and he'll... Go ahead, sir.
Good evening. My name is Alan Hatler. I've owned my home on Lakeside Lane for 8 years. The property at 26 South Saxon Avenue sits in a AAA residential district, the most protected zoning classification this town has. Those protections are part of what every family in this neighborhood relied on when we bought our homes, whichever side of the district line we live on. This area was zoned this way on purpose. In that district, the code permits two kinds of things. Families living in single-family homes, because that is what the district is for. I'm sorry. Yeah, this area was zoned this way on purpose. In that district, code permits two kinds of things. Families living in single-family homes, because that is what the district is for, and a short list of civic institutions that serve those families. A house of worship, school, library, places people go to and come from. What's proposed here is neither one. It's an institution where people live. Whatever name it's given, that is a dormitory, and the code already decided where dormitories belong in this town. In other districts, expressly listed and only by special permit, after a public hearing. This was not a use code overlooked. The code made a choice about where it belongs. The January 21st response to zoning inquiry, the building division letter this appeal is about, unmade that choice, and calling it an accessory to the school doesn't change anything. The town's code tells us what accessory means. A garage can't be bigger than the house it serves, and a church's thrift shop is capped at 10% of its building. An accessory is the small thing attached to the main thing. What's proposed here is not a small thing. It is a full-time residential use of this property, sleeping, eating, living around the clock every day. The school day ends, the living doesn't. That is not an accessory to anything. That is the use. And let me say this plainly because it matters. This has nothing to do with who the applicant is or how anyone prays. The question is what the use is, not who the people are. The town's code actually treats religious schools better than secular ones. A parochial school is permitted here as of right, while a private secular school requires a special permit. And nobody standing here tonight objects to that. Our objection would be for word for word identical if this were a secular boarding academy or the old seminary itself reopening. Federal law says a religious institution cannot be treated worse than a secular one. No one here proposes that. This code treats it better, and we don't object to that either. What no law provides is an exemption from zoning itself. And the only thing we ask is that no applicant of any faith or none be excused from the process that binds everyone else. And no one is saying this property cannot be used. It can be used today for what the code prescribes for that district. And if the owners want more than the code provides the path for that too. A use variance from this board or a petition to the town board for a change of zone. There is a path. It comes with notice to the neighbors in a hearing like this one. That path is not a response to zoning inquiry, a letter issued by a plans examiner without notice to anyone, resolving the largest land use question this neighborhood has faced in 50 years. I respectfully ask the board to reverse the response to zoning inquiry and require this proposal to take the path the law provides. That process is the only protection a homeowner has. Do not decontextualize this AAA neighborhood. Thank you.
Thank you, sir. Please, no applause. Next. We ask that you keep it as short as possible and on point.
Hi, Rob Buetti, 55 Lawrence Lane in Bay Shore, longtime resident. My mother lives, she's 90, she lives right about where that Red Sea is on there. And as Miss Genovese so eloquently and passionately put, the people that live in that community are 55 and older. We are asking that the hardship that this school may have not be transferred to the neighborhoods around. That's all we're asking. Do not transfer the hardship. Keep it within that border and make sure that they are within the rules and regulations that the town puts forth. Because there'll be noise, there'll be traffic, they will be adversely affected. When people bring up the Harrow School, if you went there, you know that is nowhere near any private houses, nowhere near. These people are 10 feet away. Their fences border, and they will hear everything, they will notice everything, and those people are going to be affected, just like the people to the south and the people to the east of it. Thank you.
Thank you, sir. Next, please.
Hello, board. My name is Kevin Whalen, 10 Meadow Farm Road. It's just an observation, but I just wanted to bring up the point that the Muslim prayer, called prayer, is 5 times a day, average 2 to 5 minutes per prayer. And I just wanted to bring that to your attention, not that you don't know it already, but it's going to affect. It's happening to my relatives who live back in Brooklyn. It's happening already to them. It's very, very disturbing.
Okay, thank you,
and
sir.
I'm just curious about it. So
Thank you.
that's it. Thank you.
Thank you. Next, please.
Good evening. I just had a question before
Name and address.
My name is Carrie Kroll, and 660 Locust Avenue, Bohemia, New York.
Okay.
I just had a question after all this code talk before I read what I had prepared, if I might ask.
If you want, you can submit that statement, and we can make that part of the record instead of you having to read it.
What we like to do is, rather than.
I did. I
hang
have
on,
something to
hang-
submit,
hang
and I
on.
have a summarized version.
Right, why don't you do this? It just makes it so much easier for all of us. You can submit that, and then just tell us what you think. The 2,
I
3,
am.
4, 5 points. I mean, you
I
can
am.
read
I
it.
prepared a shorter version, but I have an actual question in Prince of Courts. Okay. So in Town of Islip, Article 3, it's Islip Wild Animal Exemption, allows educational institutions in AAA zoning to possess certain animals that would otherwise be restricted. However, this requires explicit permission by school administration. Does the town have any restrictions for this?
wild
And
animals?
if so,
I think that's governed mainly by the New York State Agriculture and Markets Law.
okay, Article
I can tell you
26.
because of my-
I'm familiar.
My daughters are very interested in this, that there's a lot that you can't have.
Yeah, I'm actually worked on the New York State puppy mill law that passed after 7 years. So thank you, and I'll look further into that. All right, I'm just going to hold it because it's too high. Okay, thank you. Good evening, Chairman, Vice Chairman, and members of the board. My name is Carrie Kroll, and I'm a resident of the town of Islip. I have submitted a written statement regarding the proposed development at 26 South Saxon Avenue in Bay Shore, New York. I respectfully request that it be entered into the official record and considered as part of the board's review of this application, 53326. I would also like to briefly summarize my comments. My concern is whether the full scope of what is being proposed has been clearly defined, properly evaluated, and determined to be consistent with the character of this residential neighborhood and the requirements of the town's zoning code. My concern is this: a district that has historically been characterized by single-family residential homes is now being asked to accommodate what appears to be a 140-person live-in campus operation, including an assembly hall that, according to the applicant's own engineer, has been sized for approximately 206 occupants. This raises a fundamental zoning question. Where in the town of Islip zoning code is a school, whether religious or secular, with an on-site residential housing for students and staff authorized as a permitted use in the residential AAA district? That question is central to this application because the issue is not simply whether a school is permitted. The issue is whether the specific use being proposed, including residential occupancy, housing for students and staff, assembly functions, guest accommodations, events, weekend programming, and other related campus activities, is authorized and appropriate within this zoning district. The application is described as a parochial boarding school. However, the materials available to the public appear to describe something broader, a residential campus operation with a level of occupancy and activity that may extend beyond what many residents would consider consistent with the established character of the neighborhood. The question before this board is not simply what this property is called. The question is what this property will actually become. And that distinction matters. The decision before this board will establish the framework for how this property operates for years to come. It is therefore essential that the board have a complete understanding of the maximum scope and intensity of the proposed use, including the number of people on site, the range of activities, parking demand, traffic impacts, public safety considerations, and the potential effects on surrounding properties. I respectfully ask the board to ensure the record accurately reflects the complete scope of the proposed operation and that any determination clearly defines the nature, scale, and limits of the use being considered. My request is simple, that this application be evaluated based on the complete picture, not merely the title or description attached to it. I appreciate the responsibility this board carries and the careful consideration required, excuse me, when making decisions that affect the entire community. Thank you for your time and consideration.
Thank you, ma'am. Next, please.
These are the ones to submit it. I made copies for each of them. Thank you. How does this stand here? Want to hold it? Oh, sorry.
Hi, Alex Joy, 89 Root Avenue. One thing I just wanted
In
to...
what town?
Islip.
Thank you.
One thing I did want to bring up that was not talked about, and it's on their website, I'm reading it right now, is that it says Bayshore Academy will become a center for early childhood education and an Islamic daycare. We were told it was going to be a school for 7th and 12th grade. I'm not sure in what high school a daycare or early elementary is going to be an accessory, as we'll call it. And also, where are the children coming from? Are they living with the staff? Are they getting dropped off? Will it affect traffic? So, just a question.
Their students or the boarding students?
No, the daycare. Will that be
I
being
don't-
dropped off
Oh.
twice a day? Will it be morning daycare, after daycare? Will it
I
be
don't,
4
thi-
hours?
I mean, okay, thank you, ma'am.
But just something to keep in mind, something that was not brought up at all. Thank you.
Thank you, ma'am. Next, please.
Good evening. My name is Corey Stella. I live at 20 Grant Avenue, Islip. I'm a United States Marine Corps veteran. I served 5 years. I also have a degree.
Thank you for your service.
I appreciate it. I have a degree in political science, and I'm an aspiring law student as well. So I want to remind everybody in this room that we're actively at war with Iran, and these Islamic centers are not.
Okay. Sir, it's not.
This is relevant. Let
No,
me speak. Thank you.
No, it's
This
not.
is
Unfortunately, it's
relevant.
not, sir.
This is relevant. I'm a United States veteran. I will speak here. This is my right.
Not.
This is my right.
No.
Officer, will you please escort this gentleman?
I'm getting escorted out? Look at this. Look at this. I served my country Adrian, you're escorting me out?
You can.
You're escorting me out?
Wait.
Let me speak. I have two questions.
Stop.
I came in.
Stop. You can stay. Wait.
I wanted to ask
Wait. You can stay. You can stay. You can stay, but we're not having that rhetoric on the record.
It is relevant, sir.
No, it is not. We're the board. We've determined
it's relevant.
No.
It's relevant
No.
to my question,
No.
sir.
If you have a zoning
Do you have a
question,
question?
I have two questions.
we're not
sir.
here to
What are your
degrade any
questions, sir?
religion.
What are your
My
questions?
question is there's a brand new Islamic center, 45,000 square foot Islamic center in Melville.
Okay.
So why do we need another Islamic center in Suffolk? Well, that's Nassau County. In Suffolk County, since we do not have a large Muslim-born native population. My second question is, what are the academic requirements, the student requirements? Are there visa students? Where are they coming from? What economic influence will it have on the town? What benefit will it have us? Because what it seems like the third-party vendors, are they coming from New York City? Are they coming from local? These are important questions. Are the local, because I'm 31 and I can't afford a house here. So how are all these people affording it here?
Okay, sir, unfortunately, we can't answer either one
I
of those
understand, but
questions.
those are two questions that are
fair.
very relevant, and I
Okay.
appreciate your time, and I appreciate you
Thank you,
letting me
sir.
speak. So have a good night.
Have a good night. Next, please.
Good evening. My name is Isla Balkaitis. I live at 20 Joyce's Way in Bay Shore. My home is within a couple hundred feet of the property line of the subject of the applicant's community. I feel that a boarding school in this area is completely inappropriate and just plain wrong. The community is really tired of fighting our own government to do the right thing. I live on Joyce's Way, as I said, in the Windcrest community that abuts the property. It's quiet, it's peaceful, it's a 55 and over community, has 43 residences, 11 of which border this property directly. Just think of this, if this was your home. These property lines in the back are probably 50, 60 feet, and then there's the spiritual center. Is a boarding school with the noise that 120 teenage boys can generate on a recreational area, would you want that in your backyard? Less than 100 feet from your house. How about 120 teenage boys walking through your neighborhood? Just think about it. I don't think anybody wants that. This commotion to our genteel neighborhood will be extremely disruptive and not in character with the existing surroundings. I'm angry and I'm disappointed that our government, who is here to represent our best interests, would allow this boarding school to exist. Many of the quality of life issues the community had with the potential assisted living facility prior to this, housed on that property, are the same issues that we're going to have. Significantly increased traffic, shifts of supervisory personnel, visitors, food deliveries, package deliveries, garbage removal, trucks, utility trucks, and many others that I can't even think of. Another issue is evacuation. Part of that property is a flood zone right by the creek. I live by the creek. I see what happens. This last rain we had, it fills up back there. If evacuation is required during extreme storms, how will this facility manage such a large group and still have the availability for the remainder of the peninsula to evacuate? Has that been looked at? This decision to have a boarding school as an accessory use should take thoughtful and time-consuming consideration, and I appreciate that you're here tonight listening to this. Prior to this, we didn't think that that was the case. We deserve that from our government. The community did not want a commercial enterprise as it was not zoned for such. However, how is a boarding school not considered a commercial enterprise as part of it exists to maintain the financial sustainability of the facility? I'm saddened that this local government is fighting its own government to do the right thing in denying this boarding school. If permission for a boarding school is granted, precedent will be set throughout the town. Once this Pandora's box opens, it can never be closed. A boarding school should not be allowed to operate at this location or any other location in the town with a residential zoning. This neighborhood does not want a boarding school, and I believe any other neighborhood in the town would not want this one as well. Once again, a boarding school in this area is inappropriate and just plain wrong. Thank you.
Thank you, ma'am. Please hold your applause. Next, please.
Good evening. My name is Jennifer Tira. I reside at 9 Boyd Avenue, Bayshore, New York. I'll skip the zoning part.
Do you need a spelling on the last name?
Autera. A boarding school creates the conditions for a 24-hour, 7-day-a-week usage very similar to the previously proposed and denied assisted living facility. This high-density usage inherently brings commercial-like characteristics, including increased traffic, noise and light pollution, overflow parking, and commercial deliveries on a regular rather than intermittent basis. The Cornell Doctrine is a foundational land use precedent based on the 1986 ruling in Cornell University versus Bagnardi, and established that religious and educational institutions serve the public welfare, and local municipalities cannot place unreasonable zoning restrictions on such. However, the New York Cornell Doctrine does require a balancing test. Educational and religious organizations are not entirely exempt from local zoning, and zoning boards must balance the institution's needs against the potential negative impacts of the neighborhood. We are not against a house of worship or a day program. We are asking for a balanced consideration with regard to granting a boarding/dormitory school, which could be compared to assisted living for children. The denial of the assisted living facility established and recognized that a high-density usage of this property is not within the residential characteristics of this small residential peninsula, and identified the slippery slope if this type of development was allowed. Additionally, a 9/11/2024 County of Suffolk Department of Economic Development and Planning report concluded not to allow high-density development on this property. I have a copy of this comprehensive report for your review, but the highlights include: 1, more than 50% of this parcel is on a FEMA AE flood zone, which presents hazard to emergency personnel and vulnerable populations, specifically seniors, for evacuation. Are children not a vulnerable population? 2, high-density development is not in character with the predominant building type and density of the neighborhood. 3, impact of emergency evacuation of current residents, as we have only 2 egresses for exit, Dagnon Boulevard and Saxon Avenue. Note that Dagnon flooded this past weekend. And further high-density development can impact flood patterns for adjacent properties and Saxon Avenue. I am additionally requesting that an updated CEQA review ensue. In conclusion, I would like to reiterate that our stance, once again, has absolutely nothing to do with who is occupying the property. The concern is simply how the property is being developed, zoning conformity, and net negative impact to the current residents of the neighborhood. My home is the biggest financial and emotional investment of my lifetime. I not only considered the house, but the area. I am only separated from this property by Saxon Avenue and one house. I would not have purchased my home next to any entity that functioned on a 24-hour, 7-day-a-week commercial-like capacity. Therefore, one could surmise that other potential buyers would evaluate this similarly to me, and that this proposal could result in net negative property value. I simply want to enjoy my home and the peace and tranquility of my neighborhood that I truly cherish. Thank you. Yes, these are the County of Suffolk reports.
My name is Marie-Lose Edma. Last name is M.A. I'm from Bayshore, 51 Belford Avenue, 11706. Just want to tell you that my neighborhood is not happy for what we hear. It's really going to change the neighborhood. I understand a lot of people, when they come to a place, they want to come because they have money. Money takes you anywhere. It's not supposed to be like that. As a social worker graduate of LaSalle University in Pennsylvania, I'm telling you, this is going to be detrimental for the resident. It was parochial, and if you look in the Bible or anywhere you look, since it's the Bruno, we don't want to talk about the Bruno, Parochial, the word is parochial, for parish. So if they're going to change everything to come with their money to put the boys over at Saxon Avenue, it's going to be detrimental. And I'm saying thank you for having me, and please leave the neighbors the way they are. I raised 3 beautiful children from the Bayshore School, 3 beautiful ladies like me. I think we don't need any more school, any more anything. The world is perfect like this. We just have to be great neighbors. Good night.
Next, please.
My name is Kevin Carrera, 41 Connecticut Drive in Oakdale. I just had 2 very quick points. One of them has to do with the dormitory as incidental use of a parochial school. On the second district ruling that you seem to be relying on, I just wanted a clarification for the record. Did that say always or generally? Because if it did say generally, then there is wiggle room as to when somebody makes a determination as to the amount of use and whether that dormitory would automatically be subject to that appellate ruling. The other point I just wanted to make a clarification, there was a lot of fast and loose talk by the applicant of the Harrow School, and I know that this board is very well educated on exactly how much parcel the Harrow School sits on and its history and whatnot, so I'm not going to belabor it. I am just going to add for the record that to the west, there's about 100 acres of marshland, tidal marshland, buffering it, and to the east is that private community and another 50, 60 acres of woods buffering it, and then obviously to the south, the Great South Bay. This little postage stamp has 0 of that. Anyway, that's all I have to say. Thank you.
Thank you, sir. Next, please.
My name's Giselle Simonetti. I live at 35 Joyce's Way in Bayshore. My property abuts the Montefiore Spiritual Center. I have lived in the town of Islip for 61 years. I grew up here, I raised my children here, and I chose to remain here when I retired and downsized. As a real estate professional for more than 37 years, I understood the type of community in which I wanted to live and spend my ending years. I chose Windcrest because of its peaceful, quiet residential atmosphere. Before purchasing my home 3 years ago, I reviewed the zoning of the neighborhood property, especially since I've been in real estate for so long. It was reassured by its AAA residential zoning. I'm deeply concerned by the proposed use of Saxon as a boarding school. I don't have an issue with it being a day school, but I do have an issue with it being a boarding school. AAA zoning exists for a specific purpose. It's the town's most restrictive residential district and is intended to preserve the character and intensity of residential occupancy in the neighborhood. Residents make important decisions about where to purchase homes and reliance on those protections. In my view, treating this proposed use as an accessory use or otherwise allowing it to bypass the applicable residential occupancy requirements would fundamentally alter the neighborhood. A boarding school with communal living would affect the area's character, natural ambience, noise levels, traffic, population density, and ultimately, property values. The fact that the use is described as a school does not lessen those impacts. I'm also concerned that a determination regarding the residential district appears to have been made by a building plans examiner without prior review by the Zoning Board of Appeals. A public hearing, a notice, an agenda, or an opportunity for members of the public to be heard. When I needed a 2-foot extension on my house, I had to apply for it, and all my neighbors got letters in the mail so that they knew I was extending my kitchen. We got no notice here. How is that possible? My understanding is that this matter should receive appropriate review through the town's established zoning and planning processes. I respectfully request that the Planning Board and Zoning Board of Appeals fully review this determination and the proposed use. Ensure that all applicable town code requirements are followed and correct any error that may have occurred. The residents and the surrounding community deserve a transparent process, and the zoning protections which we relied on. Thank you for your consideration.
Thank you very much, ma'am. Next, please.
Hello, Greg Collins, 45 of Wicks Avenue. I live directly directly west of the subject property. I've lived there for 32 years. It's never been used as a boarding school. I'm concerned over the intensity of use as far as having privacy. I'm currently in a very private area in the back across the canal. I'll have no privacy once it would be turned into a boarding school. There's no screening or anything that's abuts the property. I won't have quiet enjoyment, and based on the videos, which they say they're not going to do, but the board won't have that type of discretion to make decisions if they don't go through the proper ISLIP channels. So I just ask and second what everybody else said, that it goes through the proper review of the board, and the board should just, hopefully consider the turnout tonight of how the community would like a decision. Thank you.
Thank you, sir. Next, please.
My name is Lori Bergen, and I live at 45 South Saxon Avenue, directly across the street from this property. My first opposition to this project goes to the scale of the project. For the last 5 years, we fought Sunrise Assisted Living. If you take religion out of it, the scope is the same. It's the same size. The traffic impact that it will have on our neighborhood is the same. And, we bought this property 19 years ago. My husband and I raised our kids here. We fell in love with the quiet residential neighborhood. Over the last few years, with all of the massive construction with the Northwell Hospital and the medical buildings, the traffic has gotten crazy, and this is going to make things actually worse. It's not zoned for boarding students at this level, and both boards voted on multiple occasions to not allow the Sunrise Assisted Living facility to be built there due to the large scale, and this is really no different. So I ask you to please consider what this would mean by opening this up to a boarding school. I want to speak go back to the Harrow School for a minute, because I don't think anybody mentioned, it's not apples to apples here. The Harrow School is on 170 acres of land. Between 40 and 80 students living in there at any one time. This is 13 acres that this amount of students will be living on. So it's not the same. I don't know how this was approved. It really seemed like it went under the radar. We had no notice about this. There were no postings or public process that the law requires. And it's just not how government is supposed to work. So that's all I want to say. I oppose this. Thank you.
Thank you, ma'am. Next, please.
Good evening. My name is Anna Chan, and I live directly across the street from the proposed Bayshore Academy. When my family chose to purchase this home 10 years ago, we did so knowing we were moving into a AAA neighborhood, a community of single-family homes where the zoning was intended to preserve its residential character. We relied on the zoning protections when making one of the largest investments of our lives. The proposal before you is not simply another home or a neighborhood school. It's a residential boarding school that would house approximately 140 teenage boys. That's where I want to stop you. I have a 16-year-old girl who's going to be directly across the street, a stone throw away from 140 teenage boys. This is any parent's nightmare. So consider that. If you woke up one day and realized that's going to happen, what are you going to think? How are you going to feel? Are you going to be able to sleep at night? It's not just a regular day school. It's going to be 24/7. If it's a day school, when my daughter goes to school, she comes home, they're gone. They're going to be there when she comes home. They're going to be there when she's walking the dogs. They're going to be there when she's riding her bikes with her friends. And the fence, I don't know what they're going to do, if they're going to change it, but right now, they're going to be looking at her when she's riding back and forth. And most of you know what goes on in a teenage boy's mind, okay? So that's kind of where I'm going to end it. I hope you do the right thing. At least, you know, the intensity of this project, who's going to be there? It's going to impact my family and a lot of the young families in the neighborhood. There are kids riding back and forth. There are people pushing strollers. They're, you know, they're all going to grow up in this area with 140 teenage boys or more eventually. Who knows? So just thank you for your time and consideration. I hope you would do the right thing. Thank you.
Thank you, ma'am. Next, please.
Good evening. My name is Deborah Mitchell. I'm a resident of Islip for the last 44 years, 100 North Ocean Avenue. I have watched the town of Islip, a beautiful town. I love my home. I love living here. But I've watched when little projects have developed and have increased traffic. I watched Union Boulevard go from a 4-lane highway to a 2-lane highway, and it increased traffic on our road. I watched them put up traffic lights. One traffic light increased such a traffic jam on Ocean Avenue, North Ocean Avenue, that it was ridiculous. We were breathing in fumes for hours till traffic subsided. And I had to close windows, had to run air conditioning because of it. I'm rather upset that a little over a year ago, I was here representing, a lawyer was here representing a buyer of a piece of property of our church. And 10 residents got up upset that a doctor's office was going to increase traffic in their neighborhood in Bayshore. And 10 residents stood up, and this board knocked down the decision to have the zone changed. This room has been full tonight. It has been full. And these people vote. We've been residents. We care about our community. If you only hear the 10 residents that get up and you don't hear the rest of us and each applause, if people are too shy to get up and say anything about this, that they're against it, that they don't want the traffic, they don't want the influx, they don't want the implications surrounding all of it, if you ignore their voice tonight or their applause in between on every speaker, then shame on this board. It's an egregious situation that we have to face after we've sown into our communities. I have fed the homeless in this community. I have provided food pantry for this community. I have cared for people out of work during COVID during this community. I kept our doors open all throughout COVID in this community. Please, please hear your residents. Please, I beg you, I beseech you by the mercies of God. Thank you.
Thank you, ma'am. Next, please.
Good evening. My name is Jim Gaffey. I'm a 22-year resident of the town of Islip. Love this place.
Can we get your address, please, Mr. Gaffney?
My address is 20 Willoughview Court, Bohemia.
Thank you.
My family owns the property south of Bunford, down by the water. Only been there a few years. It's a magnificent place. We all know the history of Bayshore, several hundred years old, the heritage, the amazing homes that have been there on that road for 200 years. And I really believe, and I agree with all of these wonderful people who've turned out today, this is a huge group, and they're very passionate. And they're passionate for a good reason, and I think the board can read it. And I implore the board to do the right thing. And the right thing is not only just according to the code, which I think that the attorneys made a very clear case to block and deny the use that is presently proposed. But I think the primary point that I would like to make is I really don't believe that it will stay at 140. I think it'll go to several hundred, and then after that, maybe 1,000, because as I said, it's 13 acres, and you can put X number of heads per acre, and voila, you got 1,000 people in a few years. And what do you do? How do you turn the clocks back then? Thank you.
Thank you, sir. Next, please.
Good evening. My name is Ray Scambati. I'm addressed at 812 Bayshore Avenue, West Islip, New York. So there's been a lot of back and forth tonight about the zoning. I actually here have the applicant's website, basically describing some of the purposes of the Islamic Center. I just want to read some of their own words, kind of talking about it. Bayshore Academy will, emphasis on will become a center for, among other things, early childhood education / Islamic daycare. I believe it was pointed out earlier in the night how that is at odds with what they testified, that it would be a 7 through 12 school. So that is directly at odds. And then later on the page, a point that was hit multiple times tonight, they say, Bayshore Properties offer a unique opportunity to establish a full educational campus, which will provide large gathering areas for community programs and an outdoor space for youth and community activities. Also, as the applicant's lawyer said earlier in the night and was also addressed, they have, in this hearing, reputed that. So I listen to these hearings, I see what is said on the website, and what I'm seeing is they are making claims on the website that is directly opposing what is being testified at this committee, this hearing. So I'm not an expert, I'm not a lawyer, I don't know the law, but the way I kind of see it is they're talking out of both sides of the mouth. They're either lying to their customers on their website with their promotions, or they're lying to us here in this meeting. Firstly, my question is kind of, which one is it? Are they lying to their customers? Are they lying to the town? And then B, if they're willing to lie to someone, whether it's their customers or the town, how do we know they're not lying about other stuff? And this isn't a comment on their religion, this isn't a comment on who they are, but they have, based on their own words tonight and what's on their website, proven a pattern multiple times. They're lying. They are lying about what's on this website and what they're saying here. So why should we trust anything they have in their documents and their applications and anything? And I specifically think of the mother who just testified about her teenage daughter, because I think that's a very reasonable concern that she has. Earlier in the night, the applicant's lawyer testified, yes, there will be strict rules on the teenage boys at this facility, but if they're willing to lie about the daycares and the age ranges, how do we know they're not lying about the rules on the teenage boys? I think that is an extremely relevant question that the board must consider, and that the community is probably considering. So I guess my question is, both for the room and for the people in front of me, do we trust them? It doesn't seem to me like we should, based on their documented pattern of lying, based on their testimony and what's on their own website in their own words. Thank you. God bless.
Thank you very much, sir. Next, please.
Hello, folks. My name's Leonard Nijek. I live in East Islip, 37 Greenwood Avenue. Got a couple questions, and I'm just trying to keep myself calm because I get very excited and very loud. One, the zoning of that building, does it last forever? In other words, it's been vacant for over 20 years. It goes, follows the land? Because I'm having a problem with that right now in another piece of property, not here. That they changed the zoning on me, and the deed says one thing, it can be changed. Well, the question here, that's one of the questions, that it's been vacant for a long time. And I think people who moved into the neighborhood in the last 20 years assumed that it would remain quiet and it'd be a tranquil community to live in, which I used to go down the end down there and go clamming all the time at the end of Saxon. It was really great back then. But the question is that you people represent our future. The decisions that you make matter. I've been here arguing other cases, like the bowling alley by me, that was turned into a nursing center, or whatever it is. And it affects us, because now the seniors have no place to go. The kids don't know what to do with themselves. And we now have a bunch of seniors that we have to pay extra tax on for an ambulance, because they're not providing it. We've asked them for help. They're not going to help us. So your decision-making here really matters. It represents every person that showed up here. Our future is in your hands. And I got to tell you, I don't think it's going so good. You build more houses, same roads. You turn around and use water all the time, same aquifer. You're asking us to cut back on water when you put more houses in. It don't make sense. Why do you put the cart in front of the horse? Because the law says so? Challenge the law. I challenged the law many times when I sat on the school board. I didn't always win, but the idea I forced a compromise favorable to our community. If you don't stand up and say something, then they accept you as a yes. You have to say no once in a while. It's okay to lose in court, but set a precedent where we are represented by you, where you represent our future needs, not someone else's. It matters what you say. Thank you.
Thank you, sir. Next, please.
Good evening, Chairman, Vice Chairman of the Board, community. I'm a lifelong resident of Bayshore, went to Bayshore High School.
Can we get your name and address for the record?
Sure, Severio Lombardi. I live at 1 Huron Drive in Bayshore. Truthfully, after hearing both sides of the story, I don't think the applicant truly knows what they want to do with this property, whether it's a daycare or a high school or a boarding with a high school. But what I did hear them say today is that this is going to be grades 7 through 12. And I did hear them say that they're looking to have 140 students board there. And I believe I also heard someone else testify today that there's only 2 egresses on this block. And so as a lifelong resident of Bayshore and a graduate of Bayshore High School, the 6 or 7 hours I was in school, we went off campus, okay? And I didn't have a car my first or second, third or fourth year, okay? So I believe I also heard some commentary about the number of trips. Are you also accounting for the foot traffic? Because these kids are not going to sit in their rooms all day. And I could tell you, when I went away to college, I didn't have a car either, and I spent the least amount of time in my dorm room and the most amount of time out and about in the streets, hanging out with my friends. And I'll also add that I doubt that these rooms are decked out with 3 TVs and computer stations for however many people they intend to keep in a room. I guess my point being is that but there's only 2 means of egress to get out of the street. These are teenage boys that are going to flood the streets when they're bored and they want to get off campus. So you need to also consider that, not just the car traffic, but also what the intensity of this building is going to do to the community with just these teenage boys out on the streets. That's all.
Thank you, sir. Next, please.
Good evening. My name is Fred Weber. I live at 161 St. Mark's Lane, Islip. First and foremost, thank you to all of you. This has been the amazing amount of patience that you guys have shown. I understand you guys are here to decide one thing, whether or not this is accessory or this is, whether or not the dorm is an accessory or if it's, thank you. However, we've gone through all this other crap. I guess my question is, this ruling that you guys will make, will this be precedent that will go forward? Can other cases use this as precedent in the future? Or is it individual, like you said? Is every property itself an individual decision? Okay.
It's complicated because I think it was Mr. Campanelli or Mr. Bertolino. They've merged now. Every case is different. Every case is separate. Every case comes with its own unique issues. So it's a difficult question you're asking us, whether or not it sets precedent. The next case may have different issues.
Okay.
So I wish I could answer your question. We'd look brilliant, but I can't.
All right, I grew up in Mineola and I watched what happened there. I'd hate to see that happen here. The only other, and please don't call it grandstanding, the only other thing I would point out is where is the applicant? And Why aren't they listening to the community? I don't think they really want to join the community.
Technically, sir, the applicant's sitting right next to you.
Well, that's their counsel.
Where are the opponents? And why aren't they listening to the community? I don't think they want to be part of this community.
Okay, thank you, sir.
So, thank you.
Good evening. Gerard White, 40 Angela Lane, Bayshore. I have want to ask for a little clarification. It seems to be a question whether this school, whether the Montfort Seminary was used as a school and a dormitory in the past. Is that a relevant point? Yes, no? Okay. Well, let me explain. I moved here in 1974, and Father McCann was in charge of Montfort Seminary, and I became good friends with him, both professionally and socially and so on. And I asked him, I says, how come Montfort Seminary was placed here in a AAA zone property? And he said to me, he says, well, we were grandfathered in. I said, well, what does that mean? He said, well, as long as we're here in this building, we're allowed to be here. And that's the end of it. And I assumed that meant maybe after they would leave, it would go back to AAA zone. And I don't know if that's true or not, but that was the impression I got. I mean, I can also testify that the place was never used as a school. There was never instruction going on in there. And there was never used as a dormitory. It was strictly used as a retirement home for a disabled priest. And I asked them, are they still getting instruction on how to preach? He said, no, they're retired. We do religious services here, but there's no instruction going on in the building. And, well, I mean, what else can I say? I mean, and it wasn't used as a dormitory. At one point, I spent some time in there during the hurricanes. He invited me and my family over to the seminary there, and there were only 4 or 5 priests there, and they were, some of them were disabled, some of them had strokes. They were not giving any instruction to anything, and the place was never used as a school. So I don't know what else you can do about that as it is. I just wanted to make that point clear to you. Thank you.
Thank you, sir.
Lucas Federico, 127 Woodland Street, East Islip. I just have a quick question for clarification. Did the applicant originally seek approval for 200 boarding students and later reduce that number to 124 during the application process? Or was the application always for 124? And if that's the case, then how does that reconcile with advertising for 200 students if they originally put 124 on their application?
Thank you, sir.
Thank you.
Hello, my name is Evan McAvoy from 20 Elder Road, Islip. So thank you all for being here. I have heard a lot of very interesting, intelligent arguments tonight. Like your seal, it says faith, but with vision. You guys all have vision and intelligence. I have none of that. I'm 16, and I'm still quite young and foolish. But I think I still have some unique viewpoint because I am still 16, and I have lots of friends who are 16. I am in a small class of 6 guys. There's a couple other girls. And we get stuck in a room, and then it's kind of like you got to like hold us together so that way it doesn't like pop out. Because like, you know, we have energy. Like we want to go do something. Because when there's a lot of people, a lot of young men, like they want to explode out in some direction. What would happen if you put 140 boys in a boarding school? I'm not saying that it's bad in all situations. I'm just saying this is very, very dangerous. Because what do? They want to explode out. They want to do something. They want to do something rebellious. And you have people who are 90 living not 200 feet to the north. So that's the first thing. And then the other thing is there are no women. It's just 140 boys. And this is the time of their life when they want to go out and they want to be men. And this could be no, it's not dangerous, it's disastrous in that way. So, thank you.
Do I have to identify myself?
Yes, please.
Okay, I can't speak then because I was going to come out on behalf of this, and as a result of January 6th, I don't need somebody smashing my head open and getting a presidential pardon. The fastest of the line. Okay.
Thank you, sir. Is there anyone else who'd like to be heard in this matter? All right, I'll take a motion to reserve decision.
Okay. Motion, second.
Second.
Matter is closed.
Mr. Chairman, members of the board, thank you for your time. Good evening.
You did one. Personal request. Keep an eye on that guy. I said 11:10. That's the type. I've been watching him all night. I saw him all night. At least he's not getting stiff.